tend to have deliberations through, using city administration to communicate and come to some sort of a decision outside of the meeting, which is not what you're describing at all. But I just want, in your mindset, keep in mind that, is this eventually leading to deliberations among you? Not us, but you. Is it being used for that purpose and
Or
to
could
shy
it
away
lead to
from
that?
Pardon me?
Or could it lead to that if it
Could it lead to that indirectly?
Indirectly.
Yeah, other channels.
And you can always bring it up at a council meeting in your comments, if you feel that other council members need to see that, and that actually more broadly shows the public that you're paying attention to the things that they're sending in, and maybe have sent it in directly to you, so.
Yeah, but I was gonna say, like, in the past, councils have said, they have not ever responded. We've never done that prior to City Manager Bellman coming on. And then a council member would bring it up when they had their council member comments. So they would say, we received an email and I just wanted to address it, that kind of thing. But I do agree with, City Manager Bellman. I think we can find a way, unfortunately for us, is that we thought it would be very easy and it's turning out to be more difficult. But we want to say in there, we have something written out that says, thank you for your email. This has been received by all of council, the city manager and the assistant to city council. It says, if it was received prior to 4:00 p.m., this will be included in the written communication. If it was received after, it will be included in the next regular meeting.
That's great.
So that's another thing, is that we don't do written communication for discussion only meetings. That's only for the regular meetings. And I think the reason we do that is because regular meetings are the ones that have more, people come to them more, people pay attention to them more. And so the reason we do that is for regular meetings.
Plus, that's where you make decisions,
Yes.
and these communications are trying to influence those.
So you, just for clarification, I don't think I heard the earlier thing, but 4:00 on Thursday.
4:00, oh, sorry, Tuesday, 4:00 on the council meeting date is our cutoff for that. Yep.
Because
Yes.
the way the preparation of the agenda is identified is like after 4:00 on Thursday and afternoon on Friday, we gotta have a unanimous add on, so. I think
That's for
everyone-
action items.
Yeah.
Communications are the only thing that's updated.
I don't read that as just limited to action items.
No, that's
so.
not what the policy resolution just says amendment.
Yeah, that's right, so I think that, you could cut it off a little earlier,
Or we could amend it.
or we could amend the resolution.
I will say from when I was in AJ's position too, that's just, we have always done it that way. And I know that was the policy
Probably
from the
nobody talked
council,
to us about it.
but I do agree. Yeah, I agree that it should be written down. And so that's something that we can definitely write down and clarify.
I wasn't sure that applied to communications.
Perhaps we can have a more thorough, I know we have a lot to cover today.
Yeah.
I do know
We can
that,
discuss that.
yeah, it does refer to, any item being placed on an agenda, but that is interpreted to mean might have some.
Needs to be in by noon.
So council has until 5:00.
It isn't like we've never amended those before,
Right.
this is just a stack of all the amendments to
Oh.
the resolution that
Perfect.
governs how we work.
I was gonna say today, I feel a little bit weird. I feel like the student teaching the teacher because you both were on my first council when I started in AJ's position. So, much more history than I do.
I don't know what much sense. Yes, back in 2022.
Okay, so,
I've got,
yes, go ahead.
I have one more question about the communication piece. So when someone sends me directly a question or a situation, I'm trying to be very cautious about giving a written response because number one, I don't want it to be perceived as I'm speaking for council. So when I have responded, my first line is, I'm just speaking for myself. Appropriate?
Yes.
But I also want to be careful about giving, I'd much rather have a conversation on the phone or to have to find out kind of more. I don't want to go back and forth with a bunch of emails, but I also want to address people's concerns. So, is there any problem with that? But when I communicate directly with someone from the community that has concerns,
Just,
and it's concerns about some of the different agenda items we have coming up, so
Sure.
I've been cautious about responding to those.
And that's good.
Other than saying I hear you.
That's good. You know, from a legal standpoint, I just suggest that you do exactly that. You make sure that you're speaking for yourself, and so there's no understanding or misunderstanding by the member of the public you're talking to that you're the city talking to them. You are one council member. I think that is important, and it's also respectful to your fellow council members who may have a different view on the item. Additionally, always keep in mind, I know, you know, our more seasoned council members know this, but anything you write to residents, public, anybody, it becomes a public record. That's why you have a city email account, and it can be, requested by anybody through the FOIA process, subject to whatever exemptions may exist. There may be some very private matters that come into your hands. There may be exemptions to the Freedom of Information Act that might not be disclosed, but I think you start with the assumption that anything you write can be, is a public document viewable by anybody. If an exemption applies, Carlito, Attorney Young from our office, or myself provide assistance to the city clerk's office in deciding that and whether it gets disclosed. But keep it in mind, just generally speaking, that anything you say on your email is a public record.
And then verbal communication with someone. So if you have two different people talking, as long as one of the two know that it's being recorded, it can be recorded, right? You can't record two separate people without either one of them knowing. But the question,
Complicated area, I'd rather get into that answer through attorney-client communications with you. It's a very complicated area of the law that has a lot of nuance to it.
thank you.
But yes, generally speaking, assume that you're being recorded is a safe place to be. Whether it can be disclosed publicly, that's the question that has a lot of nuance to it.
I understand. Thank you.
Okay, any other questions about policy resolution 2019-5 at all? And I'm gonna look too, because now that I'm talking about it, I'm pretty sure we have a written communication policy somewhere too. Do you remember
I don't remember.
that? Okay.
The,
We have AJ and Amy, there are
There's
research.
a memo from a previous city attorney that went out, so I don't know if it's a policy resolution, but I believe it's a memo.
A memo,
why
okay.
don't you get a copy of it to us?
Okay,
But
okay.
I don't remember ever seeing it.
Okay.
No.
Perfect.
Just in terms of amending the agenda, we try to avoid add-ons, right, with attachment.
Yes.
But occasionally they have to happen,
Mhm.
so we can't preclude add-ons because we require a unanimous vote to amend the agenda. So I think of written communications as kind of an add-on in that sense,
Mhm.
because the item is there and we're just adding the information. So I don't know, but it makes.
But it's not added on to that item. So a written communication that we receive from the public goes in the pile of written communications that we have. It doesn't go specific to a particular item. So I don't think it actually fits
Into this, that's what I was kind of getting at earlier. So,
So also, just to touch on that point too, if there is an add-on that comes from staff, we will always make sure to let council know that there is an add-on to the agenda. So if somebody reaches out and says, I need to add this presentation, I need to add this map, something like that, we try to avoid that, but that's something that AJ will send to you prior to the meeting, letting you all know that there was something added on so that you're not surprised.
Yeah, to the extent that, I mean, if we're talking about some point in the near future to amend these again, then maybe we need to clarify that so that it's clear that that's how it's going to be.
Okay.
And we can do that same thing with written communication.
Perfect. We'll write that down too. Okay, are we ready to move on to the next item? All right. So our city charter, I'm just gonna kind of broadly talk about this. I just put one of the points in there from the city charter that I found, that the general responsibility and authority, the council shall provide the public peace, health, safety, and welfare of a person and property. And fulfilling this obligation, the council may, upon the recommendation of the city manager, create, combine, or reorganize departments, agencies, or administrative offices in the officers of the city government. Just something that we found in the charter that we thought was interesting. Talking about upcoming charter amendments will be on the January 13th, 2026 agenda. And I put a link to the charter. However, the charter is also in all of your binders too. Charter amendments must be done by a vote of the public. We've had charter amendments in the past 5 years that have gone up and I believe failed. And we have lots of charter amendments coming up this year as well. If a charter amendment is not brought forward by the council, then it would need to be done by a petition of the voters. So they can go on a ballot by petition of the voters. If they find something in the charter that they don't like, then they would circulate petitions, bring them to the city clerk's office, and that would be something that would go on the next ballot.
Is it true that the city cannot spend money to support a yes or no vote on those things, right?
It's good to provide information, but can't advocate.
Can't advocate one way or the other. Clarity, information.
And that's what we did. I mean, even with failed tax increase, the city in their communication talked about what would potentially happen, what its content was, what revenue would come in, how it would impact. That's all okay.
City gonna send out flyers with that clarifying information.
Yeah, I don't think you want to spend a whole lot of money on that, but we have our regular news communication with our citizens, and that's where it is.
Okay.
I would say anything that you're doing, because obviously there's been people or jurisdictions that have gotten in trouble for that kind of thing. Anything that you're doing to promote, I would run through the city attorney, just to make sure, or to even not promote, but to talk about it too, if you were planning on sending anything out or.
I'd just like to be clear though, for each of you as individuals, you're elected officials, you represent the people. You personally, as in your official position as an elected official, can be out there verbally saying, advocating, you should vote yes for this around the city. You're able to do that. It's a matter of expenditure. It's under the Campaign Finance Act is where Mark is coming from. Sorry, Councilmember Meadows.
And you can call me anything you want, as long as I know what you're talking about.
Sure, well, I'm kind of informal here, so yeah. Yeah. I'll be careful. Yeah, so personally, individually, you can be doing that. It's all about the expenditure of taxpayer monies to advocate affirmatively to vote yes. I mean, the best example is if you adopted a resolution. Now, I shouldn't even say that because there's issues about resolutions that there's some leeway there. But if you issue a publication that goes out and you've spent money to print that publication and it's sent out to the community and it says vote yes on proposal blank, that's not gonna pass muster.
What if I say that from the council table?
You
During
can,
my comments.
yes, the Michigan Secretary of State has issued materials that authorizes you to speak during your comment period at a meeting. And I think I've advised in that respect.
Yeah.
And I think we did.
Yeah.
The tax issue, I think you advocated. I was a no on that, and I brought that up in my public comments, I think at least one time.
Yeah, Secretary of State has said that meeting is there's no additional cost.
Okay.
And to the extent there is any, you broke it down into minute details, it would be inconsequential and not of concern. So
That's good to know. I mean, it used to be different, right? At one point in the past. Our practice in the past, not that it matters, was to avoid.
possibly the practice and possibly prior to the Secretary of State issuing that notification to the state. Crops all municipalities. Yeah. I think, obviously the best course of action is to be careful and cautious anytime you're doing it. And as mentioned, contact me. If you have any doubt in your mind, feel free to give me a call or shoot me an email.
All right.
So, as many of you know, the city charter is what governs us. And then we also have the Home Rule City Act as well. So there are some things in the charter such as, for instance, just because this comes mine first, but the election commission. So, the state allows the election commission to pass things, but then our city charter says that the city council should be the one to do that. So, there are some things that can be, a little bit conflicting, and so for something like that, from staff's point of view, we would do something to cover both of those. If it's something in there about FOIA or something along those lines, then, and Steve can correct me if I'm wrong, the state would trump the city. So just some things to keep in mind too, when you're looking at it. We use the city charter every day in our office when we're going through, how to do something. So it's definitely a good reference when, you are looking at what the city does. Have you all had a chance to look through the charter in there? Do you have any specific questions that you want to bring up? Do you want to go more in depth on the city charter at all? Or is this a good overview of it?
Can I just say
Yes,
one
absolutely.
quick thing? So in the hierarchy of things, your charter, I think everybody in the room knows we have a federal constitution, right? Everybody knows we have a state constitution. And every once in a while, there's amendments, very rarely to the federal constitution. Rarely, but probably more often to the state constitution than the federal constitution. And because you're a home rule city, that is established pursuant to the state constitution and state laws that have been adopted under it, this city is able to adopt the charter, which is, and many people will refer to it as essentially the city's constitution. Your local home rule, it has been adopted by the voting public in the city of East Lansing, much the same as the federal and state constitutions have been adopted by the people, part of our system. Townships do not have a charter adopted by the people. It's established under state law. Villages usually do. They have a charter. So, but cities probably have the most leeway and home rule, I guess is what you call it, ability to control your own destiny through your city charter adopted by the people. And then that charter authorizes you as the city council to be a legislative body adopting ordinances. Okay, so you can kind of see the sequence of how the law breaks down all the way down to ordinances, and then it goes even further. I'll just use down because it's the easiest thing, but to policies, because policies aren't usually punishable by any sort of, criminal action. But they are rules that you establish through policies. Okay, ordinances are punishable by civil infraction or misdemeanors usually, and maybe injunctive relief. But policies generally not. They're internal and they guide how the city operates. So there's your hierarchy. We talk about the organizational structure. You also have the hierarchy of the various laws and ordinances. Don't kid yourself, they're laws. And you are a legislative body voting as a representative elected by the people to do that. So, sorry.
No, that's great. I really appreciate that.
Okay. Kind of hopefully put it in perspective.
Yeah.
Just a little clarity along the lines of your opening PowerPoint. There are only two people that work for you. The city attorney and the city manager.
Yes.
No other employee works for you. So you can't give them direction. The charter's more clear. You come through one of us.
So we cannot give AJ any direction, but we can ask her for assistance.
Right, and we did actually, I don't know if we changed the charter or it was our operating resolution. At some period in time, we were actually prohibited from communicating with city staff. So there was a change at one point. I can't remember whether we did it in the charter, but it caused the removal of a prior city manager who brought that up. Do you remember the time? And so now we are able to communicate. We can ask questions
No, absolutely.
of staff, but we cannot order staff to do anything.
Yeah.
So we can ask AJ to, hey, can you, draft a letter to do X, and if that's what the job is entailed, then that gets done, but we can't order AJ to go do anything. We have to go through
There's another way to look at it, and you can tell me if I'm wrong about this, but we have oversight responsibility, right, as a town.
Right.
And as part of that responsibility, we can ask questions, right? We can ask,
So you need to give information.
we need to get information, and that we don't necessarily, I don't think, have to go through the city manager, although it's been my practice to do that.
You don't have to, I just ask that you copy me on
Yeah.
it so that I'm.
Right.
I think that's one of our requirements, actually, to let him know that we are.
It's also a good way to look at AJ as a staff liaison to this council. So like there are staff liaisons to all the boards and commissions, she's your staff liaison. So that might be a good way to look at it too.
We also have investigative powers, which to the best of my knowledge, we've never exercised, at least in the 30 years I've been around. And
Only 30
we have
years.
subpoena power, so.
Only 30 years?
So it's a tool that may be useful at some point in time. We just luckily have never had the reason to actually utilize it.
Kind of came close with that report that came out. On the anonymous violation, complaint violating the charter. That was kind of borderline where council chose to investigate.
Okay, are we ready to move on?
Yes. Great.
All right, next up is the city manager's contract. This is in your binder.
Where are we here?
It should be in there, it's also on the website as well.
I'm assuming.
I didn't put anything on here because I'm just can answer any questions as it comes up.
Just got adjusted.
It did just get renewed, I believe, for 3 years, if that's correct. So. And we have a 3-year contract, something that is negotiated between you and the city manager.
We could change that at any time.
I was gonna say,
Yes,
that 3 years, it hasn't always been 3 years, it was a little bit longer before, wasn't it?
Typically. Because it would stay with the cycle of election. I'm not aware of it being longer.
Well, Hans was longer, but
Me too. So I really honestly thought it was, he had a 4-year deal.
Quite frankly, it's as long as the severance.
Maybe that's what I'm thinking about.
Yeah.
Because
That's all that
it's based around that.
it's as long as the what?
severance laws.
does anyone have any questions about the city manager contract? That's that.
And that, the next time that is up is when?
Well, it can
Just.
come up anytime during evaluation process, if there's a desire on either side. of The equation to adjust it.
Technically, the contract was just signed, I think, October.
September, maybe.
September, just
And that was
before
at
the
the
last
meeting,
one.
so it's 3 years from last September, so 2.5 more years.
All I'll say is I'm glad we have one.
I'm glad I had to go.
Agreed.
Okay, are we ready to move on?
Okay.
Okay. The city attorney contract. So the city attorney contract is a little bit different than a traditional contract. The city attorneys, they submit we put out for an RFP, and then the city attorneys will send in proposals, RFP, request for proposals. So when their contract comes up, they can either choose to renew, they as in you all can choose to renew, or you can put out an RFP. And then the city attorneys, you would go through there and decide either we're gonna interview everybody or who we're gonna interview, and then we would set up interviews for the city attorney to come in, and then you choose based on that. Right now we have an amazing city attorney, so it's been very helpful.
Just to add to it, you have another attorney for labor and employment law. In that,
But we've actually hired your firm, not you personally.
I was gonna mention that, yeah.
So
Yes,
We
amazing group of attorneys.
we have a lot of attorneys, it's not just me. We have a lot of attorneys that work with the city as.
he would be had a right to win this game. if it was just him.
Yeah,
So for some reason you transition to someone else, your firm would.
the firm
provide
has,
a
is the
new-
contract.
Kind of like what's the one that came to ZBA?
Beth,
Yeah. that's-
So our
she works
contract
with
with her is the same.
Time out, doesn't that contract designate you as?
It's the principal.
As the principal, yes, but we, as you know, we had a group of attorneys come in to interview from the firm. You weren't here at the time, but yeah, we had a group come in, and there's even more at the firm that do work for the city. on a daily basis. So, yeah, there's.
And that also is the prosecution arm too, is in your firm, so that's the same contract.
Same contract. We have 2 prosecutors with backup, because they obviously want vacation, but 1 prosecutor for each judge. Each of the 2 judges that are assigned to each of the 2 judges. Each city didn't have before, it had 1 prosecutor, going back and forth between the 2 judges. And it's a 5-year contract. We were just brought on, we're relatively new, as I think you know, started in July. So, yeah.
Yeah, on the RFP issue, at least since about 2015, we've actually gone out with an RFP. And in, I think, 2 instances, we just rehired the city attorney that we were utilizing, but that's, they are also participating in an RFP. Often that's just an idea to find out what we should look at in terms of the amount of money that we should, pay for attorney services. Find out.
And the labor attorney is a completely different contract.
Yes, it is.
Is
And that one is on your agenda for
Yeah, we
Tuesday
got an RFP.
to consider the RFP, so you went through that process same time in hiring Steve's firm. You hired Keller Toma, which Kari Sashatal was a principal with that firm. And then she left that firm and you ceased the relationship with Keller Toma and engaged Ogletree Dikens
Mhm.
to be your new labor and employment law, but at that same time you asked that we issue an RFP because her contract goes through June 30th of this year.
So when we talk about the people that basically report to us, both attorneys set then?
Yes, Kari would report to you too.
So in reality, we have city manager and then both different attorneys.
But you only have 1 city attorney by charter,
Mhm.
and
Right.
that's Steve's firm.
We also can retain special city attorneys, which we did on some 42 USC 1983 cases that were filed back in 2016 or 2017 and before that, because we were looking for a specialist with.
Well, you
regard
did
to
that with
federal
Michelle
civil
Crockett.
rights.
Yeah.
And,
Special
but
investigations.
that individual, the way that we've done it in the past anyway, essentially Steve would be supervising that attorney.
Correct.
So it'll be running through you.
Yes, yes.
Kari does not run through you,
She does not,
completely independent.
but we communicate on matters because it crossover.
Yeah.
Yeah. So if I could also mention bond counsel, if you
Yeah,
ever issue bonds, that's a highly specialized and certified practice of law. That you have a separate counsel for, but that only comes in when you have bonds that you're gonna issue bonds, take out loans for big projects. Additionally, the city, insurance coverage runs through the Michigan Municipal Risk Management Authority. And when a lawsuit comes in, depending on the type of lawsuit, it's called the MMRMA, they will either assign it to our office, we have litigators in our office, or if it's an employee matter, sometimes it might go to the labor attorney. Or if it's a matter that the MMRMA says, we want another attorney to assign it to because of the nature of the case, they could. So sometimes you'll see another law firm come in and represent the city. We may have a conflict, for instance, in a particular case and not be able to represent the city in that litigation. So MMRMA would assign somebody else.
So I think we're lucky that we have attorneys that talk to each other now. You and Gary communicate well, and that's great. But if we didn't have that for some reason, is there sufficient structure in your contract that the communication would be specified in the contract, or is that something we need to think about in the future potentially? For example, if we go out for a labor attorney and we have a new contract with a labor attorney, should we plan on specifying the relationship between the different attorneys?
I think we do in the RFP.
I thought I mentioned that.
Yeah, I think there's a requirement of them involving the city attorney.
Okay. And the RFP says that the attorney agrees to abide by the things in the RFP.
But by the way, I mean, it's gonna take a contract, so putting that in the contract or making sure that it's in is absolutely the right way to go.
So that might be something to note. Could do that. Okay. So I will say, very glad we have an attorney, city attorney contract.
Thank you. Happy to be here, for sure.
Okay, any other questions about city attorney contracts or the process at all? Okay. Moving right along here. And also there are bagels and coffee too, if you all need a break at any time too.
Oh, the right time?
Yes.
Oh, wow.
How'd you miss that?
So if you need a break, we can take a break if anyone. Okay. So now we're gonna get into, Robert's rules, our parliamentary procedure and open meetings act after that.
I'd like to believe they're my rules, but.
I know. I was gonna make that joke, into the lunch. I was gonna put it in there, but
Psychic?
Yeah, exactly. I write those up.
Anybody need a break?
I can use 5 minutes.
Yeah, all right, let's recess for 5 minutes. All right, we're back. After the session.
All right, so we're gonna talk about parliamentary procedure and Robert's Rules of Order. This is a manual, that is used for conducting meetings and making decisions as a group. It comes in book form, very few places have it online without having to purchase it. So if you do want a book or something along those lines, you can feel free to contact AJ. We can get that ordered for you. I will say that at 10 o'clock last night, Amy and I were on MML's website and MML has, pretty much like cheat sheets or, fact sheets for every single thing we're talking about. So at the end, I have a few links. If you both attended MML training, I'm sure that's basically what they trained off of. They're so helpful. So that's where a lot of this information comes from. Oh, okay. I think is Councilmember Grigsby, you're attending an MML training at some point, right?
Yeah. I was assuming.
Okay,
I'll check it out.
perfect. It provides a structured framework for voting procedures, and ensures that the meetings are orderly and decisions are made democratically. The rules govern discussions and decision-making within the organization, ensuring that all members have a voice. So when we talk about making motions and things like that, those all really come from Robert's rules as well. I know that this one is probably the one we get most questions on. I do have a slide about making motions and making amendments and things like that. Do we have any questions about Robert's Rules of Order, how things are structured? I know that AJ did put in your binder some fact sheets about Robert's Rules in there too. And I will say that it's easy to get in the weeds on things, so we did try to find the biggest overview for council members versus the mayor who is running the meeting, to be able to answer some of those questions as well.
I have a general question in regards to, and maybe you've already kind of addressed this, but in regards to public order and Robert's rules, as far as kind of public comment, and that being directed to council members as opposed to the audience. And overall, I think the mayor's handled that pretty well, but I do think it's an issue, and I just want to understand all the tools that are available to council in regards to not necessarily but managing it, if you will, or just kind of having quorum in a way that people feel comfortable, because we want the atmosphere to have at least a sense of people can come in and say what they want to say, but also that's directed at us and that people feel safe and not threatened in some ways. And direct is a pretty strong word with where we're at as what I see from the community, but I'm just curious if we could talk about that just a little bit.
We have it on the agenda to really get into
Oh, okay.
public comment policy and.
I'm really glad you raised that. That was one of the things I wanted to talk about under any full week.
About-
Gotcha. So-
But hold that thought because it's spot on.
Okay, we're still on Robert's rules?
Yes,
But thank you for bringing that up,
Yeah.
because it's
Yeah.
important.
At one point anyway, annually, we gave a Robert's Rules of Order. We invited boards and commission chairs and vice chairs to participate in those, or any member of any board or commission. I don't know if we're still doing that.
yes, we have
We are
one
gonna be
for
doing it? Okay.
February 12th.
I
so.
just urge
Yeah.
council members
I'll be
who may
reaching out
not
all
be
morning.
familiar to also go. But I think I defer to the city attorney, but we are not necessarily bound by Robert's Rules of Order. We have in the charter, we essentially establish our own rules. So if we violate Robert's Rules of Order, it really doesn't mean much. So we follow them as much as we possibly can. There's another, legislative, I can't remember, it's Moore's or something like that, Moore's rules of legislative activity or something like that, that are out there as well. So there are a number of things that guide decision-making bodies, like city councils. We just never have used the other ones. We've always used Roberts.
I think that's maybe my question is, I get confused by friendly amendments.
That's on here, coming up.
Okay, good, I'll let it
Yes,
go.
that's coming up here soon.
and then exactly when to do the amendments. So
Yes.
I'll wait till you
Okay,
give your presentation.
perfect.
Can I jump in a little quick,
Yes.
just to kind of give an overview as well
absolutely.
of a, being a little bit off of, what applies, what doesn't apply, and this makes it even more confusing, unfortunately, but Robert's Rules is, and I apologize if you're already gonna cover
Oh, no.
this, but it's a general set of rules of parliamentary procedure. Just by the word parliamentary, you know where it comes from, right? England, right? So it's talking about all sorts of different types of public and private organizational bodies of all sorts. It tries to cover all of them. And in it, it's through various sections, it's broken down into different types of bodies, tries to describe them, but there are so many different types of organizations out there. It's not perfect. And that's why you're not 100% bound by it. It does help provide due process though. It helps provide a procedure for orderly meetings. That's why it's called rules of order. But to complicate it even further, you have constitutional laws, federal and state. I went through those earlier, state statutes and even city ordinances that have very specialized procedures that are not contemplated under Robert's rules. And you have to follow those. Those are superior to the Robert's rules. Robert's rules doesn't really provide for public hearings and how you conduct a public hearing and what its purpose is for. So right there, you can see that there's a difference between the rules you follow and Robert's rules. So Robert's rules, I would, if I were in your shoes as you sit on the decision-making body and as mayor running the meetings, consider it your general rules that you try to follow, with the understanding that there are nuances and special situations that come into play that are different from Robert's rules. And that's where, learning about it, asking me or the city clerk at the meetings, help us keep on track here and make sure we're doing this the right way. Terminology can be important, but one example is deferring an item versus postponing an item, right? The technical term in Robert's rules is postpone. Through your practice, I've come to learn that you sometimes use the word defer. As long as the meaning is clear and there's a consensus, Robert's rules even allows for consensus. If you're operating under your own rules of how you proceed with matters and the terminology you use, there's a consensus among council on those terms, then you can proceed. So there is flexibility. It's not hard and fast. And friendly amendments is another example of some terminology that comes into play. So with that, I just want to give that overview.
Thank you, Robert.
The only thing I want to point out is that your youth commission requires you to follow Robert's Rules of Order.
Actually, the general commission, board and commission.
No, just that ordinance.
No. 2-247, or sorry, 2-246 is parliamentary procedure, requires all our boards and commissions to follow Robert's Rules of Order.
Come up. Yes.
So that's why we do the training. So
Yes, but it was Coco, I can't remember. Yeah, Coco used to do the training, but Amy set it up through MML, so they're gonna come out here and do that, which is awesome.
Is Coco still around?
I don't know, I haven't,
She has to be as old as me.
I'm not sure, I know that the last time we did, I wanna say the last time we did boards and commission training when I was in AJ's position was maybe before COVID. Or
Maybe did one in
yeah, through Coco.
24.
Who I was talking about, through
Okay.
Coco, yeah. So,
Hopefully we can get that scheduled as a yearly thing or quarterly, however
So the
often.
boards
we
and
do it.
commissions don't have flexibility, they need to follow. Well,
Right, they don't have the flexibility you have.
good have standards.
does anyone have any questions about Robert's rules or even just where to find it or helpful documents? I'm happy to send out or have AJ send out either one. just where we found all this, and I have links at the end of this too for MML, just their little helpful sheets and whatnot. Okay, we'll go ahead and move on to Open Meetings Act. Open Meetings Act is, again, it has some pretty straightforward things, like all meetings of a public body shall be open and held in a place available to the general public. Person may tape record. I know that there's some commissions that are not recorded. Obviously, somebody from the public can come in and hold up their phone and record the entire meeting, which has happened before, and that's their right to do so. Videotape, broadcast live, so if they wanted to go on Facebook Live, for instance, they can do that. Public body may establish reasonable rules and regulations in order to minimize the possibility of disrupting the meeting. So, again, they could follow part of Robert's rules or something along those lines. But just, all decisions of the public body shall be made in a meeting open to the public. So when we were talking about emails, that is something that we don't want to violate Open Meetings Act for. All deliberations of a public body constituting a quorum of its members shall take place at a meeting open to the public except for closed sessions. And then closed sessions have their own set of rules as to how to call a closed session, why a closed session is called. There's very specific reasons why a closed session would be called. And we obviously put that out to the public of why we're calling a closed session. A person shall be permitted to address a meeting of the public body under the rules established by the public body. So we established in, I believe, 2020, the rules to have public comment limited to 5 minutes. That's something, again, we'll talk about later on in the agenda, but that's something, a rule of the public body that is established. And a person shall not be excluded from a public meeting except for a breach of peace at the meeting. So again, anybody can come in and talk and say what they want.
Is that a specific resolution? Like a resolution number that established that rule?
This was pulled out of the Open Meetings Act.
No, I mean,
Oh,
but
I'm sorry.
our action, was it a specific numbered resolution?
That's, yeah, I believe it was we'll have to go back to one. Yeah, we'll
So
look.
it's in 2019.
I think based on
Is
what
it?
happened the other night, where you had to admonish somebody to, you're addressing council, I think we need to add that language
I think you're right.
to whatever we have.
So let's
You are
cycle
to
back to
address
that.
council, not to members in the audience, not to attack staff member. And,
So let's cycle back to that now, last item.
yeah,
Do you have anything you would like to add to the Open Meetings Act at all? I think one question that was asked of us was about the door to the Hannah Community Center room.
Yes.
The only thing I want is conversation you and I had about the ability to converse among council members about items without soliciting voting.
Yeah, so let me. So I'm reading from the Attorney General Handbook
Mhm.
on the OMA. One of the headings is canvassing board members on how they might vote.
Mhm.
Although similar to prohibited around the horn decision-making described above, an informal canvass by one member of a public body to find out where the votes would be on a particular issue does not violate the OMA. So long as no decisions are made during the discussions and the discussions are not a deliberate attempt to avoid the OMA. What's your view on that?
then nice,
Pardon me?
then nice.
That's a good word. Yeah, I think I've counseled earlier to that caution and avoiding doing that is the better practice. For a number of reasons, if this is a question you'd like me to look into, and I think it might be best for me to provide a legal memo on something like this for council that's more, gives me an opportunity to provide you guidance not in a, to have some time to contemplate exactly how to present the answer to that question and properly counsel you on it. But I understand that Attorney General opinion exists out there. Attorney General opinions are, all due respect to the Attorney General for sure, not binding law. That's not law. I want everybody to understand that. It's guidance, and it's guidance to state entities, because the Attorney General is the attorney for the state. You could probably describe it much better than me, but Generally,
Let me just say, my viewpoint is a little bit different than that.
Yeah.
An attorney general opinion is binding on every agency of the state unless overturned by a court. So every state agency will follow. That's why the Republicans are suing to overturn the attorney general's opinion on the $645 million that were peeled out of the budget.
yes, and I agree with that, but it is not law.
Right, it's not a statute.
It's not, yeah, so,
But it's fine.
statute and case
On
law
the state.
is law, or case law that's been adopted by, in a published opinion of the Court of Appeals or the Supreme Court, that is also law. And those judicial bodies interpret the Open Meetings Act and generally read the Open Meetings Act in a fairly narrow manner, and what those cases interpret the Open Meetings Act to say are also relevant to any discussions by you and how things transpire.
And the manual's full of citations, right? So there's a citation to a case.
Yes,
with that particular-
that's correct. That's what those are in there for. There's a substantial body of case law out there regarding the Open Meetings Act. You may see the statute and it has a number of sections, but it's finite. The case law is extensive out there. That's why we could continue talking about the Open Meetings Act for a long, long time.
Well, I don't want to prolong it unnecessarily, but I do have a question, another question about the manual since we're on this. This is subcommittees and whether they have to be posted meetings and minutes and so forth. So there's a section advisory committees in the OMA. The OMA does not apply to committees and subcommittees composed of less than a quorum of the full body if they are, quote, merely advisory or only capable of making recommendations concerning the exercise of governmental authority. Where, on the other hand, the committee or subcommittee is empowered to act on matters in such a fashion as to deprive the full public body the opportunity to consider a matter, then where a decision of the committee is an exercise of governmental authority, then the subcommittee proceedings are subject to the OMA. So we've had some discussion recently about subcommittees that are formed from various boards and commissions. And the question is, if they are merely advisory to the board or commission, are they subject to the OMA?
I would say historically, they have not been.
Right, so,
I'm gonna put this in writing.
okay,
I can't say whether that, I haven't looked at that manual in the last year or so. I don't know if it's been updated with some recent case law that has come down on this specific issue. So I will do that and follow up with council.
I think it's less relevant to us directly, but I think some of the boards and commissions are running into this issue.
Again, there's extensive case law and very recent case law on this subject,
So that
this very subject.
I'll add one thing. We had two members of council on when we purchased Hannah and we began to develop the plan to rehab and turn it into a community center. We had two members of council on that committee, Beth Schwartz and Beth Baden. And at some point, they were having a meeting and they excluded a member of the public from that meeting. My memory is, for some reason, we got slammed on that. And I'm not sure whether there was a case. I can't remember whether it was Jim Anderson. So I'm sure there was some big deal that went on with regard to it. I can't remember the reason that we turned it into an open meeting, but I think that was the result of it. So that may impact what we would do here.
I will say too, Amy just pulled up that in 2019-5, so it was in 2019, that was added, not 2020. At each, it says, it's 1.7, at each regular council meeting, the mayor shall encourage the members of the public to limit their comments to 5 minutes, a 5-minute presentation, and try to avoid duplicating arguments already presented by each agenda item. So,
and I want to circle back to that clause and we get to the public comment.
yes, so it is written in that resolution. So it sounds like there's a few things that we're gonna be talking about for that. And then I did have a question about the door to the room that we're in at the Hannah Community Center being open. Does that need to be open since the outside doors are open to the public? Or can we shut that inside door? Cause there has been a lot of distractions during the meeting.
Yeah, as long as the door is unlocked, it would be best to keep it open
Okay,
as much as possible,
Okay.
just for perception purposes, but the meeting is open to everybody. The area is posted, there are members of the public inside, it's not as though there's any indication that the public is excluded.
okay,
It's common to open a door to enter a meeting, I don't think that there's any Open Meetings Act violation. But for appearance sake and to avoid any question regarding the matter, as long as there's not noise in the hallway disrupting a meeting like we had the other night, it's best to keep that door open, make access even more obvious and easier for the public to understand.
okay.
I would say over the last 6 months, I've been regularly attending in the last 6 months. There's oftentimes people outside talking right outside.
Let's
and
try
it's very
posting signs.
distracting.
Okay,
Public meeting. Please-
Okay.
Please be quiet or something right outside
Okay.
the door.
yeah,
See if that
yeah,
works.
we can definitely do that. We can.
And just by extension, if you were to extend it to a logical sequence, would you have to open every door in the Hannah Center for
Right.
the outside world?
Yeah.
No, I mean, there is a reasonable approach to making sure the meeting is open. It's not the law would be reviewed and evaluated.
Like I said before about Robert's rules and parliamentary procedure, there's a lot of, one pagers on MML's website about Open Meetings Act requirement. That also includes, there's a whole page on how to do, if you're going into closed session, there's a whole page on closed session, and those include the requirements for closed session and things like that too. So, just keep that in mind. All right. Any other questions immediately about that? All right, motions. So, sorry, it's a little bit hard to read from here, but we're talking about a good motion and maybe a not so great motion from a minute standpoint, also from a minute taker as well. So we have Christina Marshall who sits there and does minutes. She does a great job on minutes. She's pretty great about being able to decipher things, but I will say we need to be very when we talk and we make a motion or something like that, we need to be very precise with what we say and who is saying it. So for the minutes standpoint, although our minutes are recorded, if she can't figure out in person, who said something, because multiple people are making a motion at a time, then it will be harder to going back and watching that video. So
We run into issues with that.
sometimes we do, but she's pretty good at it. I will say, if somebody else is taking minutes that maybe doesn't do it all the time, that there are some instances where it's not as clear. So
And you
From the
correct
mayor.
noise.
from the mayor's standpoint, it may be best to repeat the motion, too. That could be something that we do as well, or ask somebody who has made a motion to, or something along those lines. And I'm talking about voting as well. We have to make sure that we are voting and talking into our microphones and saying your yays or nays or that kind of thing as well.
If there are specific things that the presiding officer could do to make Christina's life easier,
Yeah.
please let him know.
Yes, yeah, absolutely. I think for the number one thing is, friendly amendments, but we'll get to amendments in the next slide. But, so a good motion has clear language. It's all encompassing of what the item is being voted on. It should start with I move. It has a second, only one discussion on the floor at a time. So we're making one motion at a time and one member speaking at a time. And then a for motion has unclear language. Has a phrase, I want to, I think we should, or I motion, which is obviously a little bit of a, just, technical thing. Cause I motion and I move, like Steve said earlier, as long as there's a, clear, concise, consensus on it, then, we know what we're talking about. For motion does not have a second, and then a for motion is having discussion prior to a motion. So we should be making a motion and then having a discussion on it, which I think we're pretty good about.
Well, that gets a little complicated, right, Steve?
Because you start to ask questions.
Well, and sometimes the discussion is what forms the motion.
If I can.
Yeah, go for it.
So this is one of the areas where Robert's rules, that you're 100% right. That's what Robert's rules talks about. You call the agenda item, ask for a motion, then you discuss the motion. That's Robert's rules textbook. You're a public body, you're a deliberative body. You're legislating sometimes, you're debating matters and deciding matters and deciding, you may not know what or how to motion on something until you learn more about it. You have staff there, you have questions for them. It's not the typical scenario that Robert's Rules is set up to address. So you're not alone. I don't know many, I know some public bodies try to do a motion right after the item is called. And it's very awkward, it's very challenging, and sometimes you don't get a motion and they end up engaging in discussion anyway. It's just the nature of what you do as a city council that you need to discuss it almost all the time prior to a motion being made. Now, there are some agenda items where it's pretty obvious, they're basic items. So the agenda items called, a motion is made, and then there might be some discussion. I guess the bottom line here is be flexible to get your work done, to get the business of the people done, is usually going to require some discussion prior to a motion being made, and that's perfectly fine. You're not violating any Robert's Rules that you've adopted and have to comply with hard and fast, especially if that pre-motion discussion, unless somebody is objecting and standing up among the five of you saying, I want a motion, and the mayor is not allowing a motion to be made, you really don't have an issue because, like I said before, you're operating under general consensus how you, as the body, want to proceed with deciding this matter. So I think you're technically still even in compliance with Robert's Rules because it enables you by consensus to adjust the way you're doing things. So if nobody's objecting among the five of you, I think you're in okay shape, and it's not a violation or a negative way to handle it.
And it's an important point because if somebody is not comfortable with how we're approaching it, then speak up, right? Then you can object and we can go back to something that's perhaps more formal, and that's perfectly fine, right? That's perfectly reasonable.
Well, I think it also, it depends on the item. And some items are gonna require a lot of discussion. And that should take place before we make a motion,
Yes.
because that may determine
We'll
what
change the
motion.
motion maybe.
We also have, which actually is a relatively recent development, which is suggested motions on the documents that support the item on the agenda. And I think one thing that we should look at is how we phrase those suggested motions, because it would be better for it to say, I move, suggested motion, I move to instead of sort of a preamble and then stick a
Verbatim.
motion in there, it'll be a lot clearer.
Okay.
In the past, we got away with, so moved.
Right.
Second vote, and whoever was recording the particular meeting said, well, it passed, but whatever it is.
I was confused by the some move thing.
Yeah, well, so moves things along pretty rapidly and is very appropriate for a lot of things. But generally on something that has required a lot of discussion, so move doesn't really work.
Okay, so it's a little more casual.
You need to put in the detail. So if you're approving an agenda or the minutes, so moved is just fine. But
Okay.
everything else probably requires a specific motion or a statement of a motion in order to move forward.
It's good
Do
clarification.
you have any qualifications on it?
Two things, no qualifications, just a notation that I noted, typically when there is a member of council saying so moved, the mayor, Mayor Brookover previously, will restate the motion, and that's what a chair is supposed to do. Robert's Rules actually talks about that the chair of the meeting, being our mayor, is, if there's any question about it, is to restate what the motion on the table is that you're voting on. Second point is, if you're not sure, ask. Say, I'm not clear what the motion is. Everybody, you may be the only one, but chances are somebody else among you might not be clear either. Say, I'm not clear what the motion is. The mayor can restate the motion or ask the motion maker to restate the motion. Different procedural ways to get to the point so that you all know what you're voting on. It's very important. So
That's
yeah,
what-
I agree.
That's what I thought was really happening until they used the state and I would say so moved, in that situation,
Yeah.
right? Okay.
Yeah.
And so what I've tried to do with that is I will ask for a motion to approve the agenda. If somebody says so moved,
Yeah.
I take it that to be recent enough that I don't need to restate the motion.
Yeah.
Right, but if there's more that happens in between, then so moved. And
And I think that actually happened the other night. I think I said so moved.
then I read the
And
motion.
then you read the
Yeah.
motion.
Yes, you did.
Yeah, that was in the report.
Yeah.
And I think that's perfectly appropriate.
So it is.
I mean, it gets things moving, but then you clarify.
Right. But again, if people have suggestions either in the moment or out of the moment, let me know. If stuff is not working for you.
Okay, any other questions about motion?
Yes, so the friendly amendment,
Okay, that's
Is that
on,
coming up?
yeah, that's on the next one.
can I just jump in now?
Yeah, yep.
So from what I understand is when we already have a motion on the table, before a second comes in, that's
So
when
you
the
can
friendly
do it after
amendment
a
comes in.
second comes in.
So it's gotta have the second first.
No, you can,
You can do the friendly amendment before the second?
if you, well, I mean, we're gonna get into it, but as I have used friendly amendments, if I make a motion and you say, do you mean X? And I say, yes, I mean X, and I didn't state it in the motion, that becomes the motion.
Like a date
And
of
you
when
can
we're
just
gonna
second
discuss this or something like that.
And you can just second. If there's already a motion on the table and you bring something up and somebody says, well, I could take that as a friendly amendment, then the maker and the second give it the thumbs up, it's part of the motion.
But we're seeing that we should not be doing that.
Oh,
You're-
okay.
So,
Tell us about
Go
it.
ahead.
So first of all, when Marie did this training back in 23, she tried to stress, there's no such thing as a friendly amendment. It's an amendment.
Mhm.
And so drop the friendly part. Somebody may not see as friendly, but it's an amendment to the motion.
because amendments should really have somebody making, or it should be an amendment and somebody seconded that amendment. And when we do a friendly amendment, there is no second to that amendment. So if you're going to do a friendly amendment, drop the word friendly and it just says, can I propose an amendment?
Or I
And
move to
amend.
amend.
Yep,
And then if you get support, then that goes.
because it's not good for record keeping sake for minutes, then we have an amendment that happened that was never seconded. And if amendment is seconded, then it should just be an amendment, so.
So what I was thinking of approaching this issue is to use unanimous consent. Right, which is in Robert's rules.
Sense is in there, I think that's where the friendly amendment concept comes from the general consensus. But I think the point that Emily is making is that it makes record keeping difficult sometimes because it gets confusing. So even though you can do it by consensus, I think, and they're procedurally, it can work and it's not uncommon among,
Boards and commissions.
boards and commissions and all across the state that this practice is used and generally accepted. Part of the consideration to keep in mind, I think, is that it's making it difficult for the clerk's office to keep track perhaps of what the motion is and who's amending it. The procedure is actually that, and I think you're gonna get into what the actual procedure for amending a motion is more detailed, but
Along that line, I mean, what's typically happening under a friendly amendment is you're trying to get the main mover and the seconder to agree to adjust what they moved
Right.
and seconded without making an amendment, so to speak.
So my view is that if you have a relatively minor amendment, right, just to a main motion, then it would be appropriate for someone to say, I would like to suggest an amendment. So they're proposing an amendment. And then what the presiding officer could do is say, are there objections to that amendment? And if somebody doesn't like the amendment, they can say, yes, I object, and then we have a second and a discussion and a vote. But if everybody agrees this is minor and can just change, then without objection, the amendment is adopted. And then you have the main motion as amended.
Yeah, and that is actually how friendly amendment works.
Yeah.
There's gotta be a maker and a second before you can have a friendly amendment. That usually happens during discussion. So you start to discuss, you realize, well, if
Well,
we change this word to this, is that okay? Is that what we're gonna?
that's basically it.
Yeah,
Can we change that to which? Anybody object to changing that to which, right? If there's objections, fine, and we'll have a second and a vote. If there's no objections, then the amendment's adopted and we move ahead. That's my inclination to try this if this starts to come up in a meeting. Because unanimous consent is an accepted procedure. And we can find out if it works from a record keeping perspective. But this would be a way to avoid friendly amendments, which.
And if we're restating the motion before we take the vote anyways, so the clerk ought
Yes.
to have it down anyway.
Right.
for example, we're gonna postpone something to February so-and-so. I just know that date doesn't work.
Yeah.
That was the original amendment,
And we did a friendly
Those are
amendment to do that.
so it's not consequential, it's not a huge part of it.
Just changes the date.
I guess I'm just because, so like, what if you make a suggestion, like, it's just a minor thing, say, well, I'm gonna suggest that, change that word, is that not what we're talking about? I mean,
So what I would, if you were to use that language, I suggest this, I would ask you, is that a motion? Are you proposing an amendment? And then you might say, yes, right? Or not, but if you say yes, then I would ask, any objections to that change? Everybody has the opportunity to say, yes, I object to that change, and then we deliberate it.
Okay,
And if there's no objections, then the change is made.
gotcha.
I think the biggest issue with that is a lot of times when friendly amendments come up, the motion is not restated with that friendly amendment in
So
it.
that's.
So if there's just people saying, can I make a friendly amendment to add this? And then it's, yep, I would accept your friendly amendment. And then we just keep going. And so the problem is that we can't just keep going. We need to restate what that new amended motion is with the change. And so that's where Mayor Altman would say, do we have a consensus? And then maybe asking them to repeat their motion with that change in it.
That's good guidance.
Yep.
All good procedure. That's
Yep.
the way.
That's good. We don't want unfriendly amendments.
Yeah. Just even, yeah.
There's no, an unfriendly amendment, it just doesn't go.
Or it could be voted. Voted down.
Yeah, that's good.
Do we have any questions about amendments in general? I will say there's two types.
That did help me a lot.
Okay.
That clarified.
Does that address your?
Yeah, absolutely. I was just wondering.
Yeah, no, that's a good, and you have a choice then to say whether, you actually want it to change or you don't, right? That's the.
Yeah, because it can be a proposed amendment too, and they can say, no, that this is what I wanted. So another thing too, it doesn't necessarily mean for amendments, but this can go for any singular vote that happens. And it could be either done by voice vote or roll call vote. So typically we do a voice vote. The mayor will call for a voice vote, and that's just for any.
I know, a little more difficult here. I don't know if it's posted out there that there's a public meeting or not, so.
But that's a meeting in progress.
Those are, the public meeting.
So there's two types of votes that can be called a voice vote or a roll call vote. So a roll call vote is when the mayor, typically I've seen it when there's a big ticket item on there they want, or a very contentious item or something that may be split. This is something that we wanted to talk to you all about. East Lansing, I think, is more unique of a community where we will always call in order of a certain order. Yeah, a lot of communities, most communities are, that I've seen too, they will call out of order. And the reason of doing that is because then they'll randomize the order. Because if you're following a certain person every single time, you may be more inclined to follow what that person votes every single time. So that may be something that we want to talk about when we talk about maybe amending 2019-5 is saying any roll call vote will be in randomized order of the council, because that way we're not inclined to always follow the vote of the person before us, since we're always following that person. Does that make sense?
I like that.
Yeah, does it work the same though? I mean, we're one of the smaller, in terms of number of, council members. Compared to a lot of communities within the state, so. Would it really apply to 5 members? I mean, what does randomization do for us?
So that would be if every time you're voting, and maybe you've been on council for a long time, so maybe you don't feel so inclined to follow what the council member before you votes, but
Probably true.
you feel comfortable voting and how.
But that just loses the problem.
Right, well, let's say it's a very contentious item and you don't know which way you're gonna go and you're following the council member before you every single time, you may be inclined to just start following, like, okay, I'm gonna vote the same way, even though it's I would say.
It also allows another council member to be first.
Yes,
Oh, yeah.
yeah, it's also our perception, I agree.
Yeah, let me be clear, I don't have any problem with
Yeah.
randomizing, I don't even know if we need to change the rules to do that.
Mhm.
You can
Start
just
doing.
do it,
Yeah.
because we don't have a rule that says you must call it in the order.
That's true.
So,
But I think putting it in writing is probably always better if that's something that we're going to start doing, because Obviously, we need for future clerk's office staff to be able to follow some sort of rules. So if we do want to do that, I think it would be better to call for roll call votes.
Very much so. I agree. It should be in writing because you don't want your clerk put in the position of deciding how the roll is called,
Mhm.
right? And that could be accusations of unfairness. I mean, the other reason of randomizing, and a lot of times the randomizing is you would provide in the rule, and you're totally right. A lot of communities do it this way. Another reason is because some council members may not like the pressure of always going forward
Mhm.
on a 5-member body. In other words, there's a good chance if you're third or fourth every single time, you're gonna be the deciding vote of whether it passes or fails. Whereas the two before you, if they're first and second every time, their vote has a little different weight in the balance of what's going on. So and it may be appreciated or not appreciated, depending on where you're sitting in
Right.
that
Is that
routine,
fair
right?
vote of mine?
So that's why a lot of communities switch to this sequential voting, and sometimes they do it alphabetically, that it'll be alphabetical, and the first vote of the meeting, the first roll call vote will be alphabetically called. They usually indicate the mayor votes last, to be honest with you.
That should be.
And so you'd have a rule set down like that, and then, alphabetically first, and then you just move down the order and you shift somebody has a last name starting with A, they're gonna vote fourth on the next roll call vote, and then the next person, so it'll just kind of keep,
We already
rotating.
call on the mayor last,
Yes.
Yes.
and we call on the mayor pro tem just before the mayor. So it's really randomizing 3 members, right? That's how
Other
we would
communities
approach
do.
this.
Yeah, other communities too have put formulas in Excel and it just randomizes the formula. And so they're able to call a different sequence every single time they vote. So that might be.
And I would say, to your point too, about being a 5-member body, that we may not want to have the mayor always go last too, because we are such a small body. We may want to just randomize all 5 members. And I think that would, I mean, to be honest with you, from a clerk's side and a person who's calling the roll, it's not the easiest thing to do every single time. It's not like it would make our lives easier to randomize it, but I do think from a perception side and also from a council member side as well, that it is a good thing that we could do for roll call votes, so.
Is this something we have to decide?
We don't have to decide it today, I don't think, but we could, when we amend 2019-5, there's, a place in the council meeting section, you just say the mayor, or the mayor shall call, if the mayor calls for a vote, it'll be a randomized vote, by the clerk or something like that.
And most of ours are, and we could always say, on consent, business, and public hearings, because our initial roll call vote at the beginning of the meeting can always just be the way, it's,
We've already.
yeah.
Yeah.
But then maybe even specifying for consent, public hearing, and discussion or something along those lines. But we don't use roll call votes very often. Like I said, it's more on the big ticket items as well.
We're overusing the fair bit.
Yeah.
And I've been using them.
But I think George used them more than anybody I remember.
Yeah.
Mostly me, but-
I feel like most business items have a roll call vote.
Yeah.
Jordan's
Yeah.
here.
And the advantage of one advantage of a roll call vote is that it's gonna be split, that I don't have to figure out who's voting which way,
Right.
right? And it's clear, and then also the person they've taken record, it doesn't have to figure out if I forgot to state what happened.
Right.
So there are advantages.
There definitely, and then there's no one saying that you can't call a roll call vote on every single item, so. Keeps our minutes taker engaged too, so.
Small thing, all the commission I've seen, some people say yes, some people say yay. Is it really, do we want to be saying yay and nay, or do we want to be saying yes or no?
I mean, I think
It doesn't.
it doesn't matter.
It's kind of funny,
Yeah.
that it's inconsistent.
So I would suggest yes and no for roll call votes, and then for voice votes, aye and nay.
Okay.
Okay, so
Okay.
all those in favor say
I
aye.
would say, I'm for whatever you want to say that is positive or negative.
You just need to say something.
Yeah.
That's a big thing, is sometimes people will get caught up in the minute and not say anything, and we do need to make sure that everybody is saying something.
For voice votes, what I don't want to get into is the situation where somebody says aye, as a no vote, and then I get confused about whether that's an aye, meaning yes, or an aye, meaning no. Because one of the procedures is to say, all those in favor, say aye, all those opposed, same sign. You hear that sometimes? That can get confusing. So that's why, with just different signs for yes and no. As long as it's clear.
Actually, yes, yes, you're voting no.
Any other questions about amendments or voting, roll call votes, things like that? Anything else, Steve, that you want to add?
No. I don't think so.
I will say, so just to wrap this up with the vote for amendments and motions, we are working with our staff a lot on agenda item reports. So Robert, who either you or I during the meeting next week, we'll just make sure to remind everybody that the motion that we put in there, and we also did an agenda item report training, and we told them to put, if there's an item where maybe they could vote either way, to put the two options in there for how to vote too. So, and we did make sure to let them know that, council is going to be using that. So we'll just reiterate that too, and put I move at the front of those as well. That was okay. All right, so moving on to boards and commissions. In your binders, you have the boards and commission handbooks or handbook. And then on the website, we have all of our comprehensive board and commission assignments. That includes the staff liaison on there. That includes the council liaison. So you all have your boards and commissions. So what is your role as the council liaison? What is the staff liaison's role, and how are applications handled? So I'll talk first about the staff liaison role, because I think sometimes AJ is confused as a staff liaison to boards and commissions. And so when you are working with your specific board and commission, you should be working with your staff liaison. They should be working on the agendas. They should be working on the minutes. They should be working on really,
They compile written communication for their specific board or
Yeah.
commission.
they will work with the applicants, things like that. So what AJ's job is handling all the applications. She handles board manager, which is our iCompass portal on the back end, with making sure that people are updated and on there. She worked with the staff liaison. She receives all of the applications and then forwards them off to the proper council member and staff liaison. If a council member needs her, to work with setting up a meeting, that's fine too, but they really should be working with the staff liaison for that board to be setting up for those kind of things as well. And then your council liaison role is attending the board and commission meetings, working with the staff liaison and the chair of the board, and then working within your commission. I know you have all had a couple months now on boards and commissions. Do you have any questions that come up immediately about those commissions?
I think in 2 years to have a meeting right away after the election. Make sure we're ready for that's been my biggest learning curve.
Or boards
is
and
all the boards
commissions.
and commissions, and I'm still learning and growing, but I think that would be, and I've had the help of the mayor. Has helped me through a lot of that stuff, but I think,
Okay, I want to clarify something.
No organization meetings?
You said
just a
this,
quick,
the staff liaison to the particular commission should be handling some of these communication issues, or?
So, and like particularly setting up like, interviews. So if you're gonna be interviewing the
Well,
board of
That would
commission.
be contrary to our rules. Our rules are that the city council assistant schedules the interviews.
So AJ has no problem scheduling interviews, but a problem is that there's over 22 boards and commissions. And if we're scheduling all those interviews and
Then we need to change this.
yeah, it definitely needs to be updated. And I
Okay.
would say there's a few things in the board and commission handbook that need to be updated
Yeah,
too.
2013-2 says that the council liaison to the commission contact the commission chairperson, check availability, and then they're scheduled by the council assistant.
Does
So
it say that, it says specifically?
That's
in
that
there?
specific. So
Yeah.
we have to change these rules if we're gonna go in that direction.
And I think that's pretty specific in those rules, because I would say that there's some boards and commissions that
I know.
she can definitely help with, and then there's some that, you know,
Where in this election, there was an issue specifically with Elopac. Everything was being scheduled for them.
okay,
But
yeah.
that is contrary to what I knew the rules to be, so I started doing it myself,
Mhm.
basically.
Yeah.
But I think we need to change these rules, and we may as well take a look at these, which are specific to our liaison assignments, at the same time that we're making changes to the general rules that govern our activities at a council meeting.
Just from a staff standpoint, I would say our board and commission handbook is a little, like there's very little directive when it comes to appointments and reappointments. Some things just need to be clear, like defined better as well. So that's something from a staff point of view that we've been talking about as well. Because it is, right now, it is very hard to do the administrative part for boards and commissions for appointments and reappointments and all of that kind of thing too. So that is something we've talked about, so that feedback is helpful too. Is there any questions? I would say a lot of our staff liaisons, are very good about boards and commissions. There was a question brought up about, I think, Transportation Commission last week. And we can talk to the staff at meeting and just make sure that they are sending agendas out prior to a meeting and including the council members if you're not receiving that already.
That was clarified, he'll do that.
Okay, perfect. So even just all of the boards and commissions too, just to make sure, and especially, I think that some of the commissions, as you know, we turn over a new council and new council members taking over, there is a little bit of a curve for that, so we can make sure that just reminding all of our staff liaisons too, to make sure that they've touched base with their new council liaison, make sure the chair reaches out, that kind of thing as well.
Just a quick question, and this could be just my interpretation, but it seems like when it comes to new commission members, applications wanting to sign up for a commission, our role, I think some commissions do it different from other ones in
Yes.
regards to being part of the interview process. And so I just want to know if there's something out there that talks about the protocol, what you're supposed to do within that, because I don't think all commissions are doing the same.
I agree with you.
They are not.
They are not.
The same. There is one rule. You as liaison should request the chair to participate in interviews. That's all you're required to do. Not the vice chair, not other members of the commission, not anything like that. Even staff is optional.
Yeah, so I mean, respectfully, I think that needs to be put out to,
It's in the rules.
yeah, but they're not, as you know. So,
So I guess what you're asking for kind of the process of an incoming application, I'll just talk through that. Somebody applies on the website for a board and commission, that comes directly to AJ's email. AJ will forward that on to the staff and the council liaison. At that point, as a council liaison, you would say, we want to interview this person for this. However that happens on the back end, an interview would be set up and it should be between the chair and the council liaison. And then typically the staff liaison would be present too, because they're really, but they don't really have a say in that kind of
Sure.
thing. That's up to you all. So sometimes they don't necessarily feel like they need to be present for that because that's up to the decision of the council liaison and the chair. So keeping that in mind, we can definitely add in there something more that clarifies the whole application process, the interview process. Because I think sometimes too, people don't even get interviewed. They'll say, oh, they're good, they can go on that board. And so do they all have to be interviewed or do they not have to be interviewed? Is it only when they're initially appointed or for reappointment, do they not need to be interviewed? So that's something we could also clarify in there. Too.
yeah, I think it should come from staff, not from me, as far as kind of that and making sure that they have that protocol in place, because as I jump onto some of these commissions, you know, the liaison or some of the chairs have been there for a while, they have their own way of doing things. And so when you have a new person like myself coming in, I just think that it always should be reiterated, especially for the council member to a new commission.
Well, that's
You
good.
know, it took a long time to change the protocol that Elopac was using.
I think that's good feedback too. I can understand definitely a new council member coming on and not knowing the protocol with new boards and commission members. But yes, like you said, a lot of staff members have been here a long time and they do it So just letting council members know what their role is in the interview process and appointing new people to their commission as well. So,
There's one other aspect to it, because the board and commission liaison assignment rules as they sit today make reference to an exhibit A, which is a complete list of who appoints and who doesn't appoint, which used to be part of the rules themselves. And we need to redistribute this, because I don't think anybody really knows when the mayor does it, when the city council does it, and who's responsible for these things. So
Yeah,
if we could all get a copy of that, I think it would be very useful.
yes, absolutely.
Is that a policy resolution that you have?
What's that?
Is that a policy resolution that you have?
Well, the policy resolution from 1997-10 listed all of them. But the policy
What a great year.
resolution relating to it in 2015
Yeah.
just makes some reference to the law, you know, so I think it's helpful to actually have it laid out.
Okay.
The amount of institutional knowledge we have around here is absolutely mind-boggling.
That first one was from the year Amy was born, so that's perfect. That's great.
That's what we were celebrating.
Okay, are there any other questions about boards and commissions as an overview?
I just want to say in terms of appointments, what
Yes.
I was doing with some of the ones that I was on before, but I'm not on now, is I was letting the staff liaison drive a lot of the process, and I was happy to do that with the appointment stuff. I was in on the interviews. And of course, it's the staff liaison who is the one who recommends the appointment ultimately. But I just want to make sure we have flexibility for the staff liaison to do a lot of that work.
Yeah, and I think we do even under the current life.
I've been deferring quite a bit to staff.
I think you brought up a good point, though. We're doing a council orientation, maybe doing an initiation of boards and commissions for council members, just so that they know the process. Yeah, I think that'd be.
And I think too, that helps us bridge the gap in the clerk's office because we are like kind of the overseers of boards and commissions, but the two commissions that I'm on and oversee, I don't really have, you know, a staff liaison that I work with because I am the staff liaison. So just helping us bridge that gap is really helpful so that we can get something in writing and really hashed out too in a good process.
For example, and maybe it's not a full meeting, but it's a meeting with you and saying, this is what this commission does, and this is what this commission
Yes.
does. This is what- And then, what were the requirements? Because then we gave our suggestions, what we would do, and I knew the areas that I knew.
Yeah.
But there's a lot of commissions I wasn't really aware of what they did.
Yeah.
So I think some kind of quick overview in the first week or so after the election may be helpful.
And I think maybe that can be done at the initial meeting when we talk about boards and commissions assignments.
It could be done before the swearing in, couldn't it?
Maybe we don't
Sure, it could be.
do commission of liaisons.
Informational only.
The other issue, we generally don't make the liaison assignments until later after the election. So it's at that point where that should trigger the meeting that talks about what each board and commission does.
My point is, I think it might be good to have that before we're appointed to the commissions. So we're more aware of what each commission does.
So what choices do we
I
make?
studied myself, but,
In terms of your request to actually
Right.
represent that committee. Got it.
and that could be a more informal meeting with just city clerk, I think, or something, but, I did a lot of I was pulling everything together myself. But, it was a bit of a fire hose.
I think, to your point, I fully agree with you. I think at the first meeting, even Amy and I were just talking about how City of Lansing, they just had their swearing in ceremony of all of their new council members on January 1st. And it was just that. And so maybe it's just that in a presentation about our boards and commissions and what all of our commissions do. And then at the next meeting, that's where you all decide on, you know, maybe what you want your commissions to be, something along those lines.
But we
too.
can summarize, I mean, chapter 2 of the code of ordinances spell out each ordinance of each board and commission.
And I've learned
Even
it all.
they
I've learned it all now.
sometimes
It's
do more
just-
than what their ordinance says.
Yes. I learned it all now. It's just kind
Yeah.
of, I think even just an informal hour meeting or,
Well, we do have a meeting that elects the mayor pro tem, and swears in a new member. And you could do it at that,
Right.
after that, you know, as part of that meeting.
I'm seeing more informal, just information gathering, not any discussion. Information gathering from the brand new elected official. for the city clerk's office.
So that's good feedback for us to assemble, even if it's just a presentation that we send to you after you come on council that says all the information.
do that
That's
too.
something as simple as that. We could definitely do that.
How are we doing in terms of your agenda?
We're doing great.
Good.
Yeah.
Sorry.
No, it's okay.
This is all important. I want to make sure we're
Okay.
way off.
Next, we're gonna move on to ordinances. So, procedure and passage of ordinances in the case of the ordinance, which is our declared emergency ordinance, no ordinance shall be finally passed by the council at the same meeting as introduced. So, we now call them first readings and second readings. So a first reading is kind of the introduction of an ordinance, and then it will come back. There's some, different ordinances that are required public hearings, so you'll see those on there. We don't have a ton of public hearings other than something that is a definite requirement. So just keeping that in mind, I'm just gonna switch ahead to the next slide. And this is something that I prepared when I just talked about, and it's really, really small up there, I'm sorry, but I did a presentation for all of staff on the process, and so I thought this is something that you all might want to see, even though, like I said, it's really small. So it's just the steps on how an ordinance kind of comes about. We have a lot of questions that we get in the clerk's office from staff about ordinances and where those come from and how are those prepared. So first step is working with the city attorney. So from council's perspective, if there's an ordinance that you all, something specific that you wanted to work on, working with the city attorney, the mayor on those. And then requesting an ordinance number. So an ordinance must have a number before going on the agenda. Ordinance numbers come from AJ. She oversees all of the ordinance numbers and resolution numbers. And then there's a first reading, which is the introduction of an ordinance. And then council will decide when to bring that second reading back. I think that was another question for council or from staff point of view. So just keeping that in mind for council too.
Is it always the next business meeting?
That would be a question for the city attorney, because I think that was a question from staff too, is when, sorry, we just caught you right.
That's okay.
in the bagel, but when does this come back? And it's something that should be decided at council when that first reading is done.
Right, and I've come to understand that the general practice is to bring it back at the next subsequent meeting unless council directs otherwise. That is almost always the case. I think maybe not almost always. I think it is always the case with zoning ordinances. When you introduce a zoning ordinance, it has to go to the planning commission for a public hearing and a recommendation back to you. So that's an instance where it's not going to come back at the next subsequent meeting. For all other ordinances that are not zoning ordinances, they will come back to you at the next subsequent meeting unless you direct otherwise as part of your motion. So if the ordinance, for example, you want to refer it to a committee or a commission or board to take a look at before you adopt it and get their input before second reading, you need to say so in the motion and identify where it's to go from there, and then it would come back after that review is completed with any comments, maybe modifications to it based on those comments for you to consider at second reading and adoption. Second reading is the adoption. And at that time, I think I'm getting ahead of you, so
No, that's
I'll
okay.
stop there.
I
but
do have a
that's-
question about what you just said of second reading is the adoption. So I think the ordinances that were just on the agenda on Tuesday were deferred to the discussion only meeting as well. So that would technically be now the third time that they're coming to council. So I think, is that still called second reading then, technically?
You technically don't even need to call it second reading.
Okay,
I think that's just a term of art that has been used through the discussion process. It's
Okay.
the adoption.
okay,
That's when you're deciding to adopt the ordinance.
Okay.
What the requirement is that it appear before you at least twice.
Okay.
Before it's adopted. It has to be on your agenda at 2 separate meetings. If it takes longer and more meetings, so be it. So, and if there are substantial changes and so forth, like you're for one of the ordinances you have before you, it's actually gonna have appeared before you several times, maybe more before it's finally adopted. You send it back for further discussion, evaluation, communication with some of the public, and it's gonna be coming back to you. So you're going above and beyond.
Yeah, we're on the 15th reading of the rental changes.
It happens to be the one I was referring to, so, yeah. So you're providing even more readings or so-called readings.
We were trying to shoot for 20, but.
Yeah.
Well,
Set a new world record.
Yeah, it's
This
Make sure it's thoroughly shot.
Right.
so I have a question about terminology, and this is maybe nitpicking, but, so we used to call it introduction and
I
adoption.
never would assign that to you.
Yeah, right. Point taken. We used to call it, introduction and adoption, right, my first tour, and then somehow it changed to first reading, second reading. I prefer introduction and adoption. I think it's clearer and it doesn't get into this issue of 15th reading and if somebody proposing we have a third reading or whatever it is. Would it be horribly complicated to just switch the language and start using introduction and adoption?
Not legal, it's terms of art, so.
I would prefer it, because that's what we always did before too.
I guess in both those cases, I realized that we're considering
Yeah.
introducing and considering adopting, but
Yeah,
I think.
I like the
because
introduction.
Because we don't necessarily always, adopt it at the second time it's on the agenda, that maybe we should not title it adoption.
it used to be introduction and then consideration of.
Consideration.
Yeah,
So introduction and consideration. I like those words.
I'm really comfortable with that.
Yeah, let's switch to.
I think that does take, I wish we would have talked about this before I just did this whole presentation to staff about it, but I'll send out an email letting them know, but I think it does take that confusion out for those ordinances that have to come back several times, and then whether it's on the discussion only, or the discussion portion of it, or whatnot,
I
then
think that's great.
Did you address that introductions could be on consent?
we have not addressed that.
Well, I don't know why we would, unless, okay, I think that's really up to the mayor.
Okay.
If we have an ordinance that we're gonna introduce, and there might be substantial changes that need to be made to it, then I don't think it won't be on a consent agenda. If the mayor won't approve that.
Right.
But if it is something that we're all, it's a minor change or something like that, but we have to introduce an ordinance to accomplish it, why not on the consent agenda?
Yeah, and just to make sure that everybody's aware, if there's something on the consent agenda that you would like to discuss,
You can always
you pull it off, and that's why I ask after the consent agenda, and you should feel absolutely free to pull stuff off, because that's the protection against sneaking stuff. Right, so people should take advantage of that.
Right,
And that goes back to the rules though, because the practice, other than under George, was that basically that you get the consent agenda introduced, in other words, the motion to get it going, and the mayor would say, is there anything on here anybody wants, which is what Eric has been doing. Would rather have this on the business agenda. So you didn't have to make a motion to move it off. I just had to indicate it and bingo, it was on is that a problem?
It's in our resolution, it's in our operating procedure.
Yeah, it's in the rules of procedure for that, I believe, right?
But also, you get to see the draft agenda as a council on Thursday. You can ask for anything removed at
That's-
that time.
That's another
Consent
time.
down
to do it.
to-
You can't do that, but also sometimes something happens over the weekend
Right.
or just before
From
the
public
meeting
comment.
where you realize we need
Yeah.
more time on
Yeah.
this.
Just so I'm clear, if there's something on the consent agenda, I didn't catch it by Thursday and it's in the meeting, well, I want to talk about this on the business agenda. I don't have to make a motion, it's a
You don't.
suggestion.
So I will ask,
Okay,
after the city manager reads the consent agenda. First thing I will do is ask whether any council member wants any item removed from the business agenda. And that's your opportunity to say, I would like item X, Y, Z moved to the business agenda.
And that has happened.
That has happened. And so then once we quiesce on that, then I will ask for a motion to approve the consent agenda as amended. And then we have a motion on that. I'm gonna ask for discussion on that because sometimes people don't want to necessarily probe really deeply into an item so much that they need to pull it off, but somebody may want to comment, and Mark did that at the last meeting with the HRC appointments, right? And that was perfectly appropriate. We didn't pull those off.
Right.
You just had a comment, so there has to be an opportunity for discussion with the consent agenda. But anybody should feel free to pull anything off that they want, and then it becomes something that we have to vote on.
I confirm it is, any member can request it to be removed from the consent agenda and handled separately.
But
Or
you're
not
good with
separate.
ordinance introductions being that consent.
Right.
Can I add something to
But-
that, maybe?
I mean, if the issue is whether we should ever have an ordinance introduction on the agenda, yeah, depends on what the mayor decides, is if it's something that we need on a business agenda so people can talk about it, that's one thing. If it's, we need to, change word X on, section 4, and we have to have an ordinance to do it, why not on the consent agenda, to introduce it?
Can I always say this to Manager Bowman, but I'm like, I know the history of why we do something, but I'm not stuck to that. But something that I do think was very effective that we did used to do was introduce and refer to a discussion only meeting. So then that instead of putting it on the immediately like the introduction on the business agenda or something along those lines, it was introduced and referred to the next discussion only meeting. So that's when that discussion took place. So now it's been introduced, discussed, and then the second meeting was when it was going to be approved.
You're
So
talking about ordinances.
ordinances,
The
yes.
problem with that is the attorney doesn't attend discussion. Some of the questions are legal questions.
Yeah.
That's a problem.
And so sometimes, as you've done in the past, you pull it off consent and start discussing it there to start, or you call the attorney afterwards before the adoption, and you get ready to bring forward whatever changes you think you need to make to it.
I value the city attorney being a part of that initial discussion.
But that
I
is
think
an
it's a
option.
general.
So you're coming to discussion only meetings
No,
now?
it's not. I can help you answer the question.
Yeah, I think as a general rule, that's not a good thing,
Mhm.
but again,
Yeah.
the mayor can make that decision. And if there's gonna be more discussion, and we're kind of doing that with the ordinance that we've now got up on, you can't be at the next business meeting, is that it?
The 20th.
Yeah, we bumped it, but we're having it on the consent, the discussion only meeting in advance. So, that's one way of doing it, but we're much further along with that also, but
I think it's context dependent, right?
yeah, it really just depends on the ordinance. Yeah.
I think the wording introduction rate is good for the public too.
Yeah.
So that some people come to the first reading thinking that it's gonna be approved that night. I think that makes it clear for the public also what is introduction and then, what's the other term?
Consideration,
Consideration and adoption of the option.
consideration of the bill.
Yeah, and also, the public is still, if it's just being introduced, the public can still comment on it.
Absolutely,
So.
absolutely. But they can know now that it's not gonna be voted on.
Okay, we're ready to move on from ordinances?
Yes.
Any other questions? Great, then we're on to resolutions. So something that we are doing differently for resolutions is we are now numbering all resolutions that come across council's desk. So we still have 3 types of resolutions. We have policy resolutions, issue resolutions, and ceremonial resolutions. Typically, the only one that you'll ever see is something that says approve a policy resolution, because we won't say approve a ceremonial resolution or an issue resolution. But we are numbering all resolutions now in chronological order because it is much better for record keeping sake. So then, they can be on the website in chronological order, or they'll be in our books in chronological order. But it will be defined whether it's a policy resolution, a ceremonial resolution, or an issue resolution. So that is something that our staff is now doing, starting in the beginning of 2026. You'll see that the 3 resolutions you've had come across. I think there's more than 3 maybe, but they are numbered. So,
Are they still gonna start with like PR for policy resolutions?
We-
Or jettisoning that?
so we might add that afterwards because it does get a little confusing when you're looking at it saying policy resolution number 2026-3, and you're like, where are the other 3 policy resolutions? But it's basically for record keeping, for AJ to be able to say that's a policy resolution, that's an issue resolution, that's a ceremonial resolution. But they'll have every number, or every one of them will have a number, and then in the body, it would say a policy resolution in there.
Could we do something like 2026-3-PR?
Yes, that's, after,
Or you
instead of
could-
before,
You can, either resolution indicate time.
right?
Yes.
Just as
That makes sense.
a mnemonic tag for the number.
Yes.
The numbers are short but concise,
Right,
and remembering that they're PRs, I think, that was.
I agree.
Okay, did the city attorney weigh in on that?
So the city charter requires all resolutions to be numbered. Your,
Not sure about that.
well, you can look it up, bring up.
Well, I didn't believe that it prohibited them from all being numbered.
I
Right.
I
think
don't think there's a prohibition from that. I think the clerk is indicating from a record keeping standpoint, this is.
It required policy, it does require that we have policy resolutions, so, and those
Right.
policy resolutions be numbered.
That's right.
So those are still being numbered.
in the
Right.
city council thing.
I'm sorry, in the,
One second.
yeah,
Okay. I'm just not sure about that. For one thing, policy resolutions actually govern our activity and the activity of, they have a different power than just because even a motion to approve is a resolution, under the definition. And you are numbering those as well. So,
I mean, technically they're numbered on the agenda, right? So, but a resolution, the written out resolutions are what we're talking about. So ceremonial resolutions, if we're honoring someone, then we can go back and say, hey, MLK had a resolution in 20 blank, and we'll say when, and then we're going back and searching MLK instead of being able to search. It was on this agenda as resolution number 2026-2.
Mr. Joppa, you know.
Yeah, well. Technically speaking, motions can be considered resolutions. You don't use the term resolution. I think, as a practical matter, what we're talking about here are resolutions that are set forth in a separate document that has a title called resolution. You actually adopt that resolution. It's given a title, you adopt it, and it's given a number. Somewhat similar, not legally speaking, but in form to an ordinance, a separate document that's called an ordinance, and it's given a number. So the business items on an agenda individually don't have a separate document that you're adopting as the action of city council. So with that mindset, I think what we're talking about here are numbering just the separate documents that you as a city council may adopt. And there are three types that are separate pieces of paper with a heading of what it's about and it's labeled a resolution, and it's given a number so that it can be tracked by the clerk's office. You have adopted some language in I think this is a policy
No,
resolution.
this is the charter.
Oh, it's in the charter.
Yeah, this is chapter 6, city legislation,
Yeah, I've seen that. Yep.
Yeah. and then formal.
So, it does indicate each proposed ordinance shall be identified by a number, of course. Then it says each resolution shall be identified by the year in which it is passed, a sequential number equal to the number of resolutions passed in that year, including the resolution in question, the general subject matter of the resolution, and the date of passage. The style of all resolutions passed by the council shall be, it is hereby resolved by the city council of the city of East Lansing. So you can see it has the language in there calling it a resolved as opposed to I move, which is a motion. And I agree entirely that there is a line of thought out there that motions are resolutions of city council as maybe a technical matter or a legal matter, but in terms of what's indicated in chapter 6 is talking about all resolutions and it's setting them apart as a separate document, like I was explaining earlier. So I think I believe it's consistent and it helps with the record keeping. I don't think it's inconsistent. I think there is a policy resolution adopted that does also talk about some numbering. I've seen that.
It does, actually.
Yeah.
What it does is it says each policy resolution shall be numbered. So a policy resolution has greater power. That's the thing, our governance is policy resolution. When we pass a policy resolution that regulates how, the city operates, I think it's important So for the public to be able to look at those things separately from looking at a bunch of resolutions that may say, you know, we're on such and such a day, you know, we're celebrating the birthday of our 100-year-old resident, Joe Schmo. So the idea of just numbering them all, I guess that's okay, but if we don't keep the policy resolutions separate and available to the public so that they don't have to dig through a bunch of other resolutions.
Yeah.
I don't think that we're doing
So
our
we
job.
still record policy resolutions separately on the website,
Yes,
but all resolutions are just tracked by the.
Well, do you? Because,
Yes.
you know, it seems like it's muddled at this point. anyway.
there's a policy
Yeah.
resolution page on the website.
Yeah.
So what this would do would just be able for us to go through our records and be able to pull out any policy resolutions, any issue resolutions, any ceremonial resolutions easier because they are labeled CR, IR, PR, and they say it in the body.
So the website will have it separate.
Just policy.
It does right
Just
now.
policy.
Yeah.
They're
Says
chronological.
It's under the code of ordinance tab.
Yeah.
So you have
No,
the charter
I
and the
know,
code
I
of
looked at
ordinance.
it. That's why I was
And then at the.
not convinced that it didn't have other resolutions in it.
It just was policy resolutions when they're out.
So if I'm a resident that's poking around and looking for policy resolutions, and I go to the policy resolutions page, and I see a bunch of numbers, and the numbers have gaps in them, I'm gonna think that there's policy resolutions that are missing.
Right, exactly.
Well, I think personally, because I think that we should be really digitizing all of our records, I think there should be an issue resolution, a ceremonial resolution page, and a policy resolution page on the website.
To address your issue,
Yes, yeah,
It'll be in 02 and 01, missing from 03.
Yeah.
yes.
That's the
to
issue.
address yours, for the sake
Can
of
they have
tracking
different numbering
policies,
systems?
Hang on.
still number all the resolutions sequentially and have in parentheses policy resolution that has 01, 02, 03, so that policy resolutions can be in sequential order, but it's
Okay, that's an interesting idea. So you're talking about getting two numbers.
one in parentheses for policy, one just to track resolutions.
I think if we're gonna do that, then we talked about too, just having, you know, on our spreadsheet, for instance, from a tracking, it would be a issue resolution, ceremonial resolution, and then policy resolution tab. Policy resolutions have their own numbers, ceremonial and issue resolutions have their own numbers, but everything is still numbered, so it's easier to track. And that's fine with us from a record keeping
So
standpoint.
just to restate what you just said, what I
Yeah.
think you're saying is every resolution gets two numbers. One is sequential for all resolutions and the other one is sequential within type.
I think it would be easier to just have a type of resolution and numbered, but
Different
all
numbering systems.
different numbering system for all three types. Instead of 1 through 100 for this year, which is what we started doing last time, so we can backtrack a little bit.
Well,
too.
and I think what Mark is saying is consistent with what you're saying.
Yes.
But I think Robert would say that that's not consistent with the charter.
Yeah, the charter just says all resolutions be numbered
Yeah.
in sequential order.
But
Well,
I do agree with what you're saying too, and we can do ceremonial and issue resolutions, but I'm saying they need to have a number, and they don't have a number right now. So how we number them, I am in agreement that if we wanna do policy resolutions, you know, we don't want any gaps in them, then they can be their own. But ceremonial and issue resolutions need numbers as well.
So they do, I think that's right. And my question for Steve is whether numbering resolutions within type in your reading is that consistent with the charter?
Charter says a sequential number equal to the number of resolutions passed in that year, including the resolution in question. It does not distinguish between different types of resolution.
So if we wanted to distinguish between different types, would that be inconsistent with what you just read?
It does seem as though it would be inconsistent.
You would have to double number.
Yeah.
You have to double them.
That would be confusing too for the public if
Yeah.
they're searching, you know, I wanna look at 2026-2 and 3 different types of resolutions pull up.
Yeah.
the Same number, that might be confusing for them more so than just listing.
No, it wasn't. That's not the thought. The thought is you'd still number them all, 2026-1, 2, 3, 4, but under it, if it's specific to a category, you could list policy resolution under it, 001, to get to Mark's point.
okay, but
Yes.
the definition of resolution is in the charter. Used in this charter shall mean the official action of the council in the form of a motion which addresses matters required or permitted to be done by resolution by this charter or by state or federal law, and to matters pertaining to the internal affairs or concerns of the city government.
So that's a
If it doesn't fit into that definition, it's not a resolution that has to be numbered. So, one of the, I guess, one of the policy resolutions that we have on here is, establishing a date for budget discussion. I mean, we never used to do that. But at some point we began to give that a PR number. I don't know how that fits into being a policy resolution.
Oh, okay, but we're getting into,
Yeah, like-
I've had the underlying question of what's a policy resolution and issue resolution. I understand what a ceremonial resolution would be. So again,
You want to look at it?
I do, and I have, and I've had that issue kind of rolling around here for quite some time, because
Been percolating. No.
what is designating as an issue resolution, I have seen some and I've wondered why it is getting that designation. So I think we need to, this is getting maybe beyond the scope of this particular orientation.
It is, but it's important.
It is important.
I think staff has that question too. I think a lot of staff members don't understand
So I
what
think-
the difference between a policy and an issue resolution is, and it's hard for us to decipher too when a resolution comes to us.
And we
what
have
it is.
a couple of opportunities here. If we're gonna take a look at our operating procedures anyway, then let's have this sort of as one of the items that we want to take a look at. But here's the other part of it. If we need to clarify within the charter what a policy resolution and what needs to be numbered, we have that opportunity because we're looking at the whole charter at this point in time. So we can make those changes as we go forward.
Maybe looking at what other communities do as part of their resolutions, because they definitely don't have 3 types, most communities don't, and I know.
I agree.
Yeah,
That's why these
So-
questions are out there.
and for us too, explaining to staff what the 3 types are, is that it's literally, is it a policy resolution or is it a ceremonial resolution? Then I guess it's an issue resolution if it's not either of those
Do we
2.
need that in the ceremonial resolutions?
Well, those are kind of
The
different,
feel good thing.
We do.
Yeah.
a bunch of them.
I would say,
They're all resolutions.
yeah.
So I think that for me, the main thing is that, well, the record keeping needs to be easy, because otherwise it's not gonna.
I would say even push back on easy and just say clean. It's not very clean right now with the way it is.
And we want to avoid a situation where the numbering scheme leaves gaps within type, because that's gonna be confusing, right? To residents when they go to look at policy resolutions, if we skip from 1 to 4, because there were no 2 and 3, that's not gonna be obvious to people. So I think some sort of numbering within type is really important.
I would also say too, depending on the communication of it, so depending on how our website is set up or that kind of thing too, we could also look into that aspect as well. To see how we can help that bridge that gap of confusion too. Yes, I agree.
City attorney's thinking.
Well, we beat that to death, so.
Yeah, no, I'm not gonna go where, because it'll take us down another rabbit hole.
Okay.
But
All right, any other things on resolution?
But this is,
We've got no clarity on that.
but this is a pending issue now, right? We're gonna think about how to address this. Okay.
great, the charter amendment thought was thought provoking, let's put it that way.
Yeah, we can.
Pretty bad opportunity.
Right.
All right. Less exciting note, code of ethics. So we put at each of your station, the seats, code of ethics. This is in Division 2 of the code. Just some key things that we wanted to talk about from our standpoint, because I know there are a few issues from you all that you wanted to ask about. Annual disclosure agreements that comes out from the clerk's office, making sure that you are putting any disclosures of interest in there. That's laid out in the code of ethics too, so
We provide a vendor list, and what we will do is fill out a disclosure of interest form, and it'll be retained in the K-9 permit, so.
so if you have another job or something along those lines, yeah, you can just put it, yeah. And then the second
Are you
thing
looking
is,
for it, Mark?
Yeah, I know it's in here.
No, it's
It's,
right, it's loose.
Yeah, I put a,
It's right-
on the desk.
The second thing is, disclosing meetings with developers. Any meetings with developers, you should be reaching out to AJ with the time, names, location, and date. So, if you don't provide all those, AJ will ask for clarifying information. That all goes on the website. So that's important. And then any specific questions about the code of ethics? I know that there was a specific question about even like attending MSU games and things like that for ethics.
But just to highlight, it's not only developers that you meet with, there's a policy resolution that if you meet
I
with.
think it's 2012
Yeah,
one.
stakeholders, union,
Yes.
whatever, you have to report out with them. Thank you. You know,
Stakeholders in any kind of upcoming votes or any kind of.
No, it lists what categories in that policy.
Which,
resolution.
which
2012
section?
Let me, it's policy resolution 2012-1. I don't know if that's in your binders, but, it states that you will need to disclose any meeting with a developer, vendor, contractor, applicant, or union staff representative, the date of the meeting, time of the meeting, place of the meeting, and the names and affiliations of the meeting. So we can send this to you too. Previous mayor Brookover would just, fill out an Excel sheet and bring it over, and we would just type it up and put it on the website, so. That's always an option. You can send an email to AJ stating that you went to a meeting and then listing the A, B, C, and D of meeting time, place, names.
So if it's a quick conversation on the phone with someone. It's also included.
That-
What I understand that's not a meeting.
Oh, it actually does say this policy does not apply to meetings that are subject to the Open Meetings Act, phone conversations, mail or email communications, meetings in which no active indicated address would require council action. As discussed.
Phone conversations are done. I also want to draw people's attention to the requirements to disclose campaign contributions over $100 from people who have business before the council. That
How is
is,
that done?
Small on. Nobody.
So the disclosures must be made at the council meetings during which the named party is discussed and or decided. It's on page 7, on page 4 of the code of ethics.
Yeah, and I think that has happened in the past.
Yeah, and it sneaks up on you. You don't necessarily think about it,
Right.
but
It came up on the ZBA the other night. One of the items on the agenda was a Hagan property issue. And, I disclosed that I had gotten donations from three of the Hagan brothers. They're all $150, so over the $100. We brought it up to the commission, we referred to the city, the council. And they said, as long as there's been no agreements, I don't have any employment with them, that a simple donation is not a conflict of interest. But I want to make sure I got on the record that I had gotten it.
Well, your campaign finance finally go for reveal that they have that.
so this is a different provision, right? This applies only to us, and it doesn't define a conflict, it just requires a disclosure.
So if there is a Hagan issue on city council from here on out, I just do that publicly in the meeting, or is it something we give to AJ, or
Just the disclosures must be made at the council meetings
Yeah.
during which the named party is discussed and
You
decided.
say, hey, I've gotten contributions from this guy, and I ran. That's all.
Unless it's more than 5 years ago or something.
Yeah, there's a limit.
so with the new ordinance with the rental? This is,
They're not the named party.
okay, as long as there's not a named party in it, then it's not necessary.
Right, yeah, anytime you run into these, I'd say pull these out and take a look, especially with campaign donations. Because that's probably, I would hope, the most common situation that you're gonna run into. I'd also mention that as you read through this, you'll note that the disclosure, just as was mentioned, only requires the disclosure. I don't think it's indicating that this is an ethical violation, because campaign donations are a form of free speech, or political speech. And that's why this ordinance is so carefully worded relative to those campaign donations. It's just saying you need to disclose that they were made, and as was mentioned, they've already been disclosed, and you can even indicate that I filed my campaign finance reports showing these disclosures, but I'm making the disclosure here in the context of this decision. You know, if that donation for some reason, you know, is giving you, biasing you in some way, yeah, that might be a problem for you. But,
So at the
But as long as you
ZBA, I was
keep it
asked
open
if I
mind.
would be recused from that discussion. I said no, because I don't see any obligation or any conflict or any prior agreements to.
And there wouldn't be here either, so not be.
No, and actually, even when you disclose at a city council meeting, the council, it has happened to me, I disclosed and asked to be excused from voting, people here in the council refused.
Everybody didn't let you.
So, I mean, you know, once it's closed, it's, you know.
I just want to make sure that was clear.
Towards a unanimous vote, so it didn't matter anyway.
Yeah, so keep in mind the distinction between the disclosure and the refusal, the two separate items.
Right, and I just wanted to make sure that was above board at that ZBA, so.
Yeah, and like, you know, at the, downtown management board meeting yesterday, at the end of the meeting, a developer who's on the board, you know, brought to my, just mentioned to me that the night before the ZBA had refused to grant their,
Variance.
their zoning changes, and that he didn't know whether he'd be going ahead with this project. So, you know, they didn't ask me for any advice or comment with regard to it. I didn't know about the ZBA action until he mentioned it. So I don't think that's a disclosable item. That's just some guy telling me something that had happened.
Let me ask about timing. So we're at 11:08.
One slide left.
One slide left, okay. So one slide, then we'll take a brief break and then we'll move
Well,
on.
before we move on, I know you had questions on the attendance of MSU football going, whether that fell into a conflict of interest, so I didn't know if.
if you have ethical issues, I'd say, you know, we're in orientation. I'd say if you have specific situations and you, want to discuss them, you can contact me. I think the city manager is also involved under the ordinance with, assisting with ethical issues. So
Great.
if that's okay,
Got
yeah.
Okay, are we ready to move on?
Yes.
Okay, all right. All right, the last one is just a small part of our job, FOIA.
Small.
Even
Small. You say that to the end.
So it's on record that it's a very small portion of their job.
Yeah. 305 FOIAs. I was definitely being facetious. So Amy does all of our FOIA requests in our office, obviously. She's amazing at FOIA, so that's something that we're very grateful for. So I just want to talk about our overview about FOIA and how it's handled. So FOIA request comes in and the FOIA coordinator will route it. The city uses what's called just FOIA to receive and route requests. Very handy. We're able to track everything in there. And it's been a great asset to the city and it helps with transparency a lot. And if a FOIA comes in for a council member, it will be sent to you and the assistant to city council. So if you are seeing a FOIA being routed to you, you would get an email from just FOIA and it would say this, and that would be something, it would say, do not reply at just FOIA. And that is something that if you are getting that, AJ is also getting that as well. So that is something that you can work with the city manager, the city attorney, and the assistant to city council. So I do know when I was in AJ's position and the mayor was Mayor Meadows, he would ask me, can you search my inbox for these items? And that would be something that I was happy to do in that position. AJ will be following suit on that too. So if you have something specific.
Can you elaborate what types of FOIA you get versus not?
So, yes, so I am the FOIA coordinator for city departments excluding police and fire. So fire will get EMS reports, they go directly to the fire department. Police department has police records department and they process all body cam footage, police reports, investigation reports. If we get a personnel request for police, then we would handle that. So if that is emails pertaining to the chief of police, then that's something we would handle. So they take care of anything police department related that is outside of personnel issues. So, well, I guess personnel in terms of emails and text messages and stuff like that.
So talking about that, the only thing that AJ would not be able to help you directly with is if you have text messages or, phone messages on your phone, something like that, you could come in and we could help you with that. I'm not sure how many of you have a city phone. Does everyone have a city
I
phone?
don't have,
You don't, okay, so,
I avoid that completely, so recommendation.
so that she can help with, if you need screenshots of text messages, and that kind of thing. So just don't forget that when a FOIA request is coming in and they're asking for any and all documents pertaining to something, that don't forget about your phone as well. And then you'll work with obviously the city attorney. If there's something that the city attorney is on, then it should be in the 2 line of dealing with business, and they will be able to help you with any redactions as well.
Typically too, regarding FOIA involving the city attorney, if you loop me in, that helps me keep track of the request. Because sometimes requests will get lost and I have to make sure that we're sticking to the deadline. So 4 deadlines for all of you. A request comes in, we have 5 business days to either grant the request, deny the request, grant it impartial and deny it impartial, or extend the request. So if you just keep me in the loop, obviously you'll know because I will loop you into the request, but that's just the best way to keep track.
Can you get access to all of our phone records? I'm assuming you can.
I cannot do that, but if a request comes in, then I'll just fix with you regarding it.
Yeah, Amy is not the person that would be searching your emails or doing anything. She's the person that coordinates the request. She doesn't generate the content for it unless it's something to do with the clerk's office.
IT could
Yeah,
give over.
And that's your phone. I don't believe
Right.
it.
But the city phone, they have full access to.
No.
Oh, they don't?
I don't not believe it.
I thought they did.
Okay, one thing, I don't
Yes.
know if you got it, but and I think it would be useful, particularly for the new members. In 2015, we designated the city manager
Yes,
as
the
the
FOIA
FOIA coordinator
Yeah.
and approved a set of administrative rules that govern the work, that make the mayor the determiner of
Yep.
any appeal.
yes,
And we did that to avoid a due process issue that we thought was in place, which had the city manager as the FOIA coordinator and the determiner of any appeal on it. So,
We've already worked together on.
did you give them a copy of the administrative rules? by any
I think
chance?
I thought it would be in there, but it should be in there, but we can pull it up too. And I
Yeah.
thought we had
I didn't see
revisited
it
that
in
in
there.
2019 as well. So
Yeah,
AJ,
that's what I remember.
if you wanna look up that, I think it's policy resolution too. It might be, I know it's administrative rules, but we'll look it up and print it off real quick. So on my second bullet point, appeal should be going to the mayor. So, anything that comes in, the mayor will, be able to work with the city attorney, and then decide an outcome of a FOIA appeal. So we've already had a couple, like Amy said, and they have gone to the mayor. And
So a lot of the appeals too will be sent directly to the mayor for purposes of keeping track of those because they've been lost in the past too. I ask everyone that I put in the letter, if you're appealing this, you need to loop me in as well, just so that I can make sure that when it comes in, the mayor knows about it, the city manager knows about it, and Carlito knows about it, who is obviously one of the city attorneys. So, yes. So we all work together to make sure that a response is given timely and get a letter out to the requester. And like I said, we already have a few, so.
So it sounds like it's pretty limited action on our side. We just need to know about it.
Yep.
And then basically AJ, you staff some take care of it for it, been looking for things and worrying about it, right?
Basically, yeah.
Yeah, the administrative side, I would say just make sure that if you do get a FOIA request, that you're keeping in touch with AJ or Amy or the city attorney or all of them, to make, if you need help with gathering that information, AJ would be able to gather that information. That's the main overview. If you need help with what's on redacted, that kind of stuff, then Amy and the city attorney can help you with that too, so. But again, that's a broad overview of FOIA. I think the biggest thing is to make sure that what you're putting in writing, if you don't want it to be a headline, then just keep that in mind too, so.
So also just if anybody cares about how many requests we get, last year the city, so I in 2025, we got 306 requests. Police department definitely has their own departments where they get a lot more. They have probably 800 to 1,000 requests, and that includes investigation reports, finding footage, all of that. And then the fire department usually gets 50-ish. So it kind of varies across the board.
Is that less now that Alice is gone, is it less?
Actually, so I was tracking last year compared to other years, and
You really said that.
I was tracking last year and we were actually on track to receive less. And then starting in September, we ended up receiving more than we have in previous years. So it's roughly around 300 every single year. Yep.
And yes, this is, so it's 2018-14 and AJ's part of it. Go ahead, Steve, sorry.
I was just gonna say, the quantity of requests is one thing, but the quality or extent of each individual FOIA request is a whole other matter. A single FOIA request can take weeks to find the documents. Sometimes I've dealt with some that have taken months, and the city is able to do an extension and provide for that and require money to be deposited, not the total amount up front, but up to 50%. So there's a lot of calculating and estimating and communication with the requesters when you get these large requests. So just the numbers alone are not the full story. Some are massive and require a lot of time from the clerk's office. Departments have to weigh in and provide the information. In our office, you know, the bigger ones, obviously, we become involved in redactions. There are exemptions under the Freedom of Information Act for privacy and other matters, attorney-client privilege. There's a long list of exemptions. Those have to be evaluated and things redacted. That takes an inordinate amount of time. So I just didn't want you to get a false picture. The numbers sound like a lot, but it's actually can be a lot more than you can imagine. 5 days is the minimum. A lot of requests take a lot more time. So just to be clear on that, and then if it's appealed, then it takes additional time for legal evaluation and input to the mayor to make a decision, because it's not something you do every day. Whoever is the mayor at a given point in time. So,
I will say too, I did a presentation at Charter Review and I pulled numbers for the amount of extensions we do and how much time we take on them. And I think that in the past 2 years, that has gotten a lot better where we're issuing responses quicker than we have in previous years. So we're not issuing as many extensions, although we are allowed to under the law. So I think that's a good point of transparency as well. And then I think too, fees were a big discussion for that. And we charge fees obviously on the big ones and we're allowed to, but we are conservative with charging fees.
and the FOIA allows you to
Yes,
charge
it
the
does.
fees. It has formulas in there,
Yes.
and they're kind of conservative, like small c conservative ways of calculating the fees. So I don't think they really incorporate the actual costs.
Yes.
The individuals and the public requesting the information are actually given the benefit of the doubt on how much they're charged. And I wanted to say, I don't think we're communicating this as complaining about.
Oh, no.
I want that to be clear that this isn't complaint, this is just informing you. The Open Meetings Act and the Freedom of Information Act are sunshine laws adopted back in the 70s. Michigan's one of the more open states. They're transparency laws. We hear a lot about transparency. The city does all this to be as transparent as it can and to comply with the law. It's the job. It's part of what you and we do. It's not a complaint. It's just making sure that you understand what goes into this.
Is there a calculation in from the fees with it from like an individual in the community who's wanting this information to an organization?
It doesn't specify,
No, I don't.
but the law does allow a municipality to create a threshold of which if it's below that threshold, it could be exempt.
Gotcha.
So identify a dollar amount, if it's under that dollar amount, then.
And we do that, right? We have a
Could
bunch of
exempt,
FOIAs.
not charging that.
And there's also a dollar amount, so it's usually the lowest paid employee capable of doing the work, so it's not necessarily the person who's actually doing it, it's the person capable of doing it, so.
Gotcha.
I personally have never heard FOIA described as eloquently as Steve just did with, in regards to like how long they do take, but I think Amy's point of the fact that we issued a lot less extensions, and last year was a record-breaking year for elections, and FOIA done out of the clerk's office is something that should definitely be phrase too. So I'm just saying, I would be remiss if I didn't, but I think that's something that is very
You mean
awesome.
2024?
20, yeah, we didn't say it last year, but she.
We're into that new right now.
And I think we're striking a good balance between charging and not charging, right? For the simple FOIA is to take 5 to 10 minutes where you don't charge, right? I think, and then for the longer ones, we do, and we should, because it's staff time.
Yeah. And really quick, one other thing is your website has a lot of information on it, and the FOIA law was amended a number of years ago to say if the information is accessible on the website, the FOIA personnel can notify the requester it's on the website, and it alleviates the need to duplicate what's already posted if the individual has access and is notified of that. So
We do that a lot
goes
with
a long way.
Yeah, we do that a lot with building records because they're available on BSNA, so we typically just send that person to BSNA.
Otherwise, the request would probably, if you didn't have that robust website, the numbers would be a lot higher, I guess.
There, you know, I'm going from memory here, but I know there was discussion at the charter committee about including some language regarding FOIA in the proposals. I can't remember whether it actually made it there or not.
Yeah, I think
It did.
transparency section.
It did,
I'll be amending that.
and that's good.
Yeah.
But if the clerk's office can just sort of say whether that would make it harder or easier, then,
I would have to look at the recommendations again. I don't know often.
yeah, when that comes up, you know,
Yeah.
we're gonna want to hear, so.
Okay,
All right.
so I'm gonna suggest we take a break.
Oh, I did have one more
Oh,
slide.
yeah, okay.
Yes, these are my helpful links. MML's parliamentary procedure and all of that. I cannot stress that enough. And then the fact sheets at MML for our new council members. These are so helpful for every walk of whatever you're doing in government. So I would encourage that. And that's the end of our.
Very helpful.
Yeah, very helpful. So
Certainly some.
any questions that you all have, like we have a long list of things that we'll follow up on now and we'll send that information to, so, including this presentation to you all.
Just along that line, since the MML is up there, you know, I just recommend that new members go ahead and get involved. Apply to be on one of their boards so that they're quarterly meetings, so they're not gonna, you know, like kill you in terms of time, but it gets you to know people from all over the state who do the same things that we do on this council. It gives you an opportunity to be in on the front end of litigate or legislation that might be pending and things like that could affect us. And I just, it's worth your time, but I just recommend you do that.
Show me some more ordinances around the state about this. And I asked that. And they provided me with quite a few things, so. Very, very helpful.
Thank you for that overview. This is, I thought, a tremendously useful discussion.
Thank you for all your feedback too, so we can update for the future councils.
So let's break for 5 minutes and then we'll come back and look at the layout and then public comment. the city council room. Robert,
Yeah, so I provided you a couple, but I also got a new one that I thought I printed out. So based on some of the feedback that we were having here this is, I wanted to share as a revised version to take into account some of the feedback from staff about safety.
Yeah.
And kind of utilizing the existing layout, but also accomplishing the concern that you can't be seen. And
Yeah.
so to wing out the two on either end, to have three in the middle, and to just adjust the city staff table, but also to bring this, is it stanchions?
stanchions.
Out further to block that space in front of the council table from the public accessing that. Because we had a concern at a prior meeting, I think it was October, where some of the public was standing behind council. So the thought is to bring it all the way over and kind of lock that space down, so that the public can't approach the council table through the meetings.
So sometime with this version here, there's not a whole lot of room behind us. Behind the three sitting at the
Right.
head of the table. You sometimes walk over to bring these slips. I guess we can pass them along.
So they usually give them to the clerk and then I'll walk behind.
Is there room for you to walk behind?
Oh, yeah, this will still have some of that same space. It's not, I mean, visually accurate to the room setup,
Okay.
but there'll still be space to walk behind.
So basically, this is the same thing except for moving that farther wing, like a little bit
Both,
more.
both ways.
Both
Both
wings out.
wings, and then
So it's just
separating
that,
staff from public.
right,
Okay, I get, I didn't weigh in on it, but, anything that would replicate what we had in the courtroom, which I thought was very effective, I would be supportive of. That's with the mayor in the middle. And there were two council members on each side. The people who were recording the meeting were behind us, sitting at the judge's seat, so they were adjacent to us.
That was only one person.
And it was one person
Yeah.
before. Now it is much more difficult, but if they were off to the right, that works, which is what we have there. The other aspect of it was that, to my memory anyway, generally we had the public directly in front of us. If staff was attending, they were in the back of the room. And then if they were called to the microphone, they just come up to the microphone. We have it set up because we've got this big banquet room that we're using now. I don't know how that would work in there, but that would be my preference.
yeah, so what you have is council.
Yeah, and I don't think that's very effective, to be frank with you. I think that by having us sort of in this aspect with two members, the mayor in the middle, we can communicate better than that.
That's
Well, the other thought is where Steve and I would sit. And that's why we pulled in these two sides. It's just winging out the two ends that
I'm
currently.
understanding that. I'm just telling you
Right.
my view on that, which is that's not as effective as one of your other items that had basically a replication of the old
Which-
way that we did it.
This is,
That's what's pulled up here.
that is this.
No, that, I don't have the new one.
I understand, but the design of that is in essence this, with just rotating the room.
Yeah, and I guess, what I'm saying
Because the reds
is,
are the 5 council members.
I'm saying, if this is the mayor, then the mayor ought to be right here, 2 council members here and 2 council members there.
I understand.
And where you put the city manager and the city attorney.
City manager just moved down a little bit. The city attorney, you were there when we were in the other room. We didn't have any problem with the city manager and the city attorney sat at a table up on our right-hand side.
If I can too, I think the problem is that the tables are bigger than they were in the courtroom, and so there's more room to spread out. And so that's the difficulty with setting that up, is that everybody gets their own table now too.
Right. And, I don't know, personally, I don't care about that. But, you know, that, I don't need a whole table like that.
I like the room. I've grown accustomed to it.
Yeah.
You mean the room on the table?
The room, the larger table.
Yeah, okay. I wasn't sure if the room.
Well, I've also grown accustomed to our current setup, and the only concern that I have about it is that it's hard for me to see. Right, and so I would like to be able to, you know, I would like somebody to be able to do this, and I can catch it and say, okay, you're next.
Yeah, that's why if the mayor was in the center at the mayor's table and council members come out somewhat like this, the mayor can always see who's raising their hand and who.
Well, I gotta be
who wants to
honest,
talk.
I gotta be honest with you, like, this is an example here, I'm like trying to shift back and forth from Mark, so you can see, and I know sometimes when we're at the table, I mean, just because I have to do a lot of shifting in my seat, sometimes I feel like I'm playing that game, like,
And you're kind of stuck in between Robert and. Mayor.
yeah, so, yeah, when someone's talking to the city manager,
So let me say the other,
This would resolve a little bit, except for you would not see whoever's in this spot.
yeah, I don't have a preference of what we do, I just know that for me personally, I know sometimes it's, you know, I just feel guilty.
It's absolutely, we need some type of change.
so I have a thought, which is, I take Mark's point, that would be ideal in some ways. One of the issues, so separate and apart from that, one of the issues with this layout is that staff is sitting in front of the audience, which is not great, because the staff has their backs to the audience. I think we want to avoid that. So that's a complication of this layout. I am perfectly willing to try this new version for now to see how it works. With having a lopsided council, just to see how it works for us in terms of the communication between the council members and whether it's easier to see each other. And maybe in the interim, we can keep working on a layout that might do what Mark was suggesting.
Yeah, isn't that the layout that we used the other night? The thing you just held up?
No.
No, it's a little different.
I will say too, for your point about the courtroom, this actually does, I feel like with the staff table being like directly in front, being able to address council, because when staff used to talk in the courtroom, they stood at the podium. And so having a staff table that's back in the staff area versus like kind of kitty corner off to the side, I think helps that as well too, be able to spread out.
So are we okay with trying this for now?
Sure.
And then we'll see
And this
how that goes.
center aisle doesn't have to be right in the middle. I like how this is kind of shifted over a little bit, because
Fine.
that way there would not be public sitting behind the staff.
Yeah.
I think that would be a priority for me.
Yeah.
Is no one sitting behind the staff. There's no seats available there. Even a block off staff sign or whatever. And then that way we have plenty of space for public.
Yeah.
Even more people in the front row. I think this gives us the better access to the public than what we have right now. And that's really one of the goals, right?
Well, we
So-
we often have like a mixture, right? Like
Yes, we
the
do.
public will bleed
The
over.
right
to
time,
staff
sometimes they are, so I think it would be good to kind of keep that
I think it's a good safety.
a little bit separated.
The issue becomes
But
is
also,
staff is.
is
Working.
actually instructed, sit back in this area, right?
Right. And they're working on stuff, and so the concern is people seeing what's on their computer screen or the media. And then taking that to write stories is the reason why we're trying to create some
I
stuff.
think that's what we're doing.
So have clear signage here.
Yep.
And then come up to the podium, so then there'll be interaction with the center aisle, but other than
Right.
that center aisle, there would not be interaction between the staff and.
Yeah.
Which I'm a huge supporter of.
Yeah, we can definitely work on robust signage too.
And I think to lead to your point, sometimes it's just better when you see it. Like, is there space to put the mayor in the center and then kind of a little bit more of the arch? And then you're kind of, the two of you are on a straight row that's basically in front of the staff. But I think it's better for us to all be in front of the public primarily, because we're the officials, but thanks. So does it need to be locked in right now, or could it be setting up the room and?
No, as long as there's a
We're just
desire.
gonna try what
Yeah.
the mayor indicated.
Yeah, so we're gonna try a version of this. It's something that's gonna be trial and error once we get in the room. You have to be in there to play with it.
I think the discussion only meeting's a good one to start it.
Yeah, I think that's right.
Well, I was gonna ask about that because the discussion only meetings in the past.
Yeah.
were because they're often not attended by a lot of public. It was more of a U-shaped action because we're really interacting constantly. So I don't know, to me, we wouldn't set up the room for a discussion only meeting the same way we would do for a general discussion meeting. I mean,
So I thought that the last discussion only meeting that we had, there was pretty good flow of conversation. Was my impression. I don't know.
well, I think it was
I guess-
like a giant upgrade in discussion only meeting, so to say that.
I
So,
don't think so.
Yeah.
And so,
I would agree.
I don't think the current layout is inhibiting us all that much.
I think it was a good discussion based on the personalities and everything.
I think the only thing different about a discussion only meeting is the elimination of the city manager table. And so maybe that way we can figure out the layout based on, or city attorney, you're coming.
No,
You have to be there.
I'm going on.
The city attorney.
Thank you very much. 2 meetings a month.
We'll have to take that out, and then Steve doesn't have a table, he does.
Yeah, well, we would just have to know if Steve plans on attending and spending
Well,
his
he'll be there.
every, yeah. So that Tuesday will be the best one, but to your point, if there is a meeting where the city attorney is not attending, then we may be able to get that more round discussion set up too. So we would just need to know in advance, and then we'd be able to set up the room however. But I do think that, to your point as well, for the courtroom, we did used to have a discussion only meeting and a regular meeting set up based on the city attorney attending. So I don't know if that's as necessary because we have a way bigger room now, but that is a good point to note.
Let's try this, see how it works.
Yep.
At one point, there was some kind of discussion, even having them on an angle or something.
Yeah, we can tweak it. We'll see how it works.
We'll see how it works.
Just so that there's not,
Steve and I can sit by the exit.
well, I think even though the staff not have their backs to.
That's what I personally said. I thought it was a safety
Oh,
concern having our backs to the doors.
Because we can have tables, put your backs against the wall, looking that way, you can see the audience and you can also see all.
So are we resolved on, maybe resolved is the wrong word. Are we okay with that?
Yeah.
Okay,
the consensus.
consensus.
Yes.
All right, so then the last item on the agenda is public comment. In the interest of time, let me be the resource on this to get us started, and please feel free to jump in. I want to pick up where Chuck got us started a while ago, which was one particular issue of speakers addressing the council and not audience members. This has been something that's been on my mind for months now. We've seen an issue with this occasionally at council meetings. We've also seen an issue with this at board and commission meetings also, where in one particular case, there were at a transportation commission meeting, there were representatives from NDOT who were there to give a presentation, and there were a couple of speakers in the public who spoke at the podium who were not happy with NDOT. And one of them did exactly the right thing, which was address the commission, criticizing NDOT, but addressing the commission. Another speaker got up and criticized NDOT by turning around to face them. And so that's another case where I think we want to avoid that sort of situation. Because it creates a dynamic that does not contribute to a welcoming environment for the public or for guests. In this case, MDOT was invited by the city to be there. And I'm also concerned about staff, because when staff are there to present information, that is their workplace. And I believe we have an obligation to make their workplace welcoming and to not allow a situation where they're getting challenged by speakers from the podium. So I think this is pretty important. And I was going to suggest that we modify our operating procedures to include some language concerning that particular issue. And I can read some language in a moment, but while I'm talking, I'm going to keep talking, and I'm going to also ask if there's interest in going from 5 minutes to 3 minutes per person.
Okay, well, this is discussion.
This is discussion, and the basis for this, one basis for this is that 3 minutes is the industry standard. So what the state does, what Lansing City Council does, MSC Board of Trustees, Meridian Township, so basically all our neighbors do 3 minutes. We raised this at the NML training. The consensus is everybody does 3 minutes. That might be your experience as well, in the public comment. But
There's a room of almost 100 people, and pretty much unanimously, it was 3-minute public comments for all city councils, for the people in the room.
And
It wasn't official ballot.
the way I see it is, it strikes a good balance between time per speaker, but also access to the microphone. Right, so you want everybody, you don't want people to have to wait too long to get their turn to speak. We want to hear more voices rather than fewer.
Well, we also don't want to go to midnight all the time. But I'll just tell you that sort of the genesis of the 5 minutes was a discussion around 1995, 1996 that resulted in our very first operating procedures, which encouraged the mayor to encourage speakers to limit it to 5 minutes. That was carried forward in every amendment that we've had on this. And at some point during that last council, when they adopted the 5-minute limitation that has the running clock, that was consistent with what we have had for 30 years. But there's no magic to that. And if it has been, now we see, what I see anyway, is people who could have made their point in 1 or 2 minutes using all 5 minutes because they have this right to have 5 minutes. So limiting that to three minutes to me is not a violation of anything. It gives people an ample opportunity to make their point and also shortens the meeting a little bit, but also gives the rest of the public that are sitting in that audience an opportunity. And I think actually, if it wasn't for the clock up there with the 5 minutes on it, that there are some people, when you say at the end of the blue cards, does anybody else want to address council? We might have somebody come up there who might think, well, I've got to go up there and talk for 5 minutes. I can't really, do that. They may be not thinking about the fact that they just have to make a couple of statements. And coupled with the rule which we haven't enforced, which is to encourage people not to repeat what's already been said by somebody else, then, I think we can shorten these meetings a little bit, and we're not doing any disservice to the general public and their ability to address us on any issue. Plus, they can send us a letter, and that's all included. So,
I'm in full agreement with giving as many people access as possible. We want to hear from all the people that want to speak, right? So I'm 100% agreeing with that. But I do think sometimes people just want to fill then after they've made their point. It's like I'm obligated to fill these 5 minutes now. I think that's important. And maybe there's some kind of caveat if no one has addressed an issue and then at the end, does anyone else want to speak? Maybe someone else could fill in a gap that wasn't spoken of prior to that. Because our goal is to have public comment, right? Our goal is to have good community input. I think the 3 minutes actually expands on that, in my opinion.
So just to ask you, Steve, I think there are some councils that also sort of they have public comment at the beginning of the meeting, but they also defer additional public comment to the end of the meeting. I mean, if somebody wants to keep talking and they will, should we provide an opportunity for the mayor to say, your time's up now. If you have more to say, you'll have an opportunity at the end of the meeting, but everybody's gone, frankly. But nonetheless, should we make that offer as well, and do others do it?
Yeah, the answer is yes, others do it. There's a wide range. From having one public comment at the beginning of the meeting, or some communities have one public comment at the end of the meeting. Some have two, some have one at the beginning that, is limited in time with the understanding that there will be more time provided at the end of the meeting. So you can get to your business, all sorts of different options. The key is you have to have some point in the meeting where public comment is allowed. And that's just the basic rule. And from there, as long as it's reasonable and enables that opportunity, you're gonna be in compliance with the Open Meetings Act. As long as the time limit is reasonable, and as the mayor mentioned, 3 minutes is typical. I have seen communities that go up to 5 minutes. I've seen communities change from 5 minutes to 3 minutes because of similar things that you're talking about. So it runs the gamut, some, mostly at 3 minutes. I have to say that's the most typical amount of time I've seen in other communities. But that's just me, right? I mean, yeah, myself and my firm, we have a lot of experience with communities across the state, but certainly not every community. We haven't done a poll. So I don't want it to be thought that this is some scientific analysis of the numbers across the state, but by and large, 3 is very common.
Sure. I disagree with all of you.
Okay.
You know, and it's just a personal deal, especially for someone who started off speaking from the podium. And I know we have a lot of disparity in who's talking and what and how they do it. I just think it's a very, very important part of being able to have the connection with the public. Sometimes that connection does not always feel good, and sometimes it's not used in the way that we think is productive for our time. And, I don't think we have a choice in the matter of that when it comes to reasons why we got to these positions. And so my philosophy personally is the 5 minutes is something that, from my perspective as a council, we take pride in because we allow our constituents to be able to speak. And whether they use the 5 minutes or not, or whatever the case may be, but that's just my personal philosophy. Now, if there was a change to minutes, because then everyone wanted to kind of do that, that's fine with me. I don't have a personal thing with that. But I would be really open to having, if we did limit it to 3 minutes, that there is a second opportunity for someone to speak for 2 minutes, another part of the meeting, if necessary. But, I think that opens up another can of worms with kind of when we start talking about things, making decisions, and it just gives another opportunity for people to say the same thing, that kind of stuff. But that's just where I'm at with that. And again, if that was a change, I wouldn't have too much of an issue with it, but that's just my preference.
But that would be enabling other people that actually want to watch the governance of city council. Then they could leave at that second. If there was an additional 2 minute thing, I don't know. I think looking out for the community as a whole that want to come to city council, it's just interesting how quickly a lot of people leave. Right after their agenda item is dealt with or whatever. And when there's a lot of other issues that maybe don't deal with that. So
Yeah.
I don't know about the logistics of it, adding a 2 minute at the end, or we add a 2 minute at the end right now, and then maybe we talk about it immediately. I don't know.
And that's me not sitting at too many 12 a.m. meetings too. So, but I don't know. Unless there's like a clear reason that, we're having issues with time on a consistent basis. Or we have, a lot of disruption with the way that that's being presented, and we need to kind of curb that down a little bit. I don't know, but I don't have any issues with 5 minutes at all.
The timing has been an issue since I've been on the
Timing as
council.
far as what?
Going so late, I think it's prohibitive to the public.
Turn on
It's part of the staff, and it's prohibitive to the public of watching other issues done because they do have kids that go to bed, all these different issues.
Yeah, and
So I think
again,
that's making the meeting so late has been prohibitive to public access to our meetings.
if that's what we do, I have no problems with that. I'm just letting you know the perspective.
So I want to address the issue. So from my perspective, I think that public comment has actually been going really well. Because people are speaking their minds. And they're doing it passionately, and they're doing it clearly. And they're saying stuff that they think we need to hear. I got no problem with any of that. I don't want to change their style. I don't want to change their tone. I don't want to change nothing about that. I think, and I also don't want to tell people that they shouldn't repeat what other people have said. I think I want to repeat what other people have said, that's what they should do, because that's what's on their minds. And they've written their remarks out when they come in, they should be able to say that. I don't want to get near the idea of telling people what they should say. I'm completely fine with how they even go. I just think that I think it'd be useful to experiment with narrowing that window. And then the only other tweak that I would suggest is having them address the council.
Yeah, and I agree with that completely. And I think that, 99% of the time that's happened. It is very, I think, inappropriate for somebody to think that it's courageous, for one thing, to stand at the microphone and turn around and accuse or point a finger at a staff member, because the staff member is not in a position to respond in any way whatsoever. So I think these are comments made to council. That's what it's for, and we should very clearly limit the ability to do anything but talk to us.
Jeff, do you have thoughts on that issue?
No, I agree with that.
I mean,
I guess my question was, or I guess my inquiry about that was, okay, so what if you do that, you say that, and then it continues to happen?
Yeah,
It
it's a good
continues to
question.
be, an issue. And I guess that's where I was more at, trying to understand what is the ramifications, or what, is it just, gavel, 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 or is it just more of like, is there a consequence? So that's what I guess I was curious about.
I think that that's a really important question, because if you have a rule, then you have to have a way to enforce
Yeah,
it.
you could put the consequence right in the
Well,
rule,
what-
which is your ability to end the conversation, so to speak.
So right now, our rule is that the mayor shall encourage speakers to adhere to the 5-minute time limit, right? And then the other provision about not repeating stuff. So what I was thinking is do something parallel. The mayor shall encourage speakers to keep their time limit, whatever we decide that is, and shall encourage speakers to address the council and refrain from addressing members of the public, members of the city staff, or city guests. And then it's up to the mayor to figure out how to make that work. On Tuesday, I intervened once, and it seemed to work, and I didn't gavel. I just asked the speaker to please address their comments to the council, and that seemed to be effective. And
you
so,
also address someone in the audience,
who was out of order?
but that one, well, I love the fact that then that the gentleman came up and spoke.
And then he came up and spoke, and that worked just fine, perfect, right? It was within the process. So that would be my plan to address that issue, is I would try to be respectful, and I would simply ask them over the microphone the way I asked them to wind up their remarks because their time is expired. And whether that's gonna work 100%, I'll have to play that by ear.
And also, at the 3 minutes, if they're writing another thought, and so your time is expired, can you
Yes.
just complete your thought? Maybe so if they've got 15 seconds, they need to finish that last sentence, maybe there can be a little bit more flexibility in that.
And I've been using my judgment on that front. If so, I see the time go to 0. If I get the impression that somebody's just sort of settling in, right, for a filibuster at that point, then we're okay. But I give them 5 seconds of grace, right, and then all my time's expired. And so some of that's got to be judgment calls, but it has to be impartial, right,
Consistent.
and consistent. So that would be how I would find it.
I will say that there is a change to that time period. It's gonna look cosmetically like a punitive thing, like we're limiting people's ability to address an issue that's important to them. That's probably a minority of the people in the audience, but I just want to say that out loud.
Yeah. No, I think you're right, and I think there's, if we want to do this, there might never be a good time.
Well, this is the beginning of, essentially a new council. So every 2 years, we have a new council. So this is actually a reason. You know, this is gonna govern this council as it goes forward. The next council may have a different makeup. And there may be a different decision as to how things are done. So I think now's the time to take care of that. And if we're gonna make other changes to our governing rules, then now's the time to do it. Let's do it. Just for clarification, when you, the recommendation that they not repeat things relates to agenda items, not their general coming in and talking to us. And we could handle that differently too. You know, we allow people to, you know, I'm here on the blue card for item number 15. I want to talk about, you know, the potential expansion of the field house or whatever. And you always ask, do you want to talk about it now, or do you want to wait till the agenda item comes up? Most people want to get out of there, so they talk about it early, but we could also say, if you're here for a particular agenda item, I won't be calling on you until the agenda item comes up.
But you don't typically allow public comment on the agenda items.
And we've always allowed it to be done.
Not,
Go ahead, you're.
not during the meeting.
Yeah, absolutely.
No.
In the past, we always did.
That one's
No, it's
actually-
2.5 years I've been here.
That's not been my.
Yeah, I'm saying that in the past, if somebody said they wanted to talk about an agenda item, we'd call on them at the agenda item.
Okay. So that was done when?
During the prior, 20 years of my time
And
on.
I would hope that people would do that during the normal public comment time, just because we're getting,
Right.
if there's a stakeholder, that's different, I think.
I know we do it when there's a public hearing.
Yeah, we have to do
We say you can come up to public comment or come up
That's,
during
yeah,
the
that's how
public hearing.
commissions work.
Right. I didn't know that.
Yeah, well, we've never, other than recommending you keep it to 5 minutes, we haven't really had any specific rules that we would now be attaching to the way people, or when people talk to us and how they talk to us.
Yeah, this is the only element of a public comment policy that we have on the books, is that particular.
Right.
paragraph. So I did type out some proposed language, which I will read, and you can all give me comments on it.
Can you just send it to us and we can comment that way?
Well, I think that gets into discussion outside of the meeting. So the current language that we've talked about a few times is at each regular council meeting. Well, so here's an issue. It says at each regular council meeting, it doesn't talk about discussion meetings. It just limits it to regular meeting. That's one thing I'd like to change. At each regular council meeting, the mayor shall encourage members of the public to limit their comments to a 5-minute presentation and to try to avoid duplicating arguments already presented on each agenda item. That's the current language. What I was going to suggest, and we can go in any direction people want with this, I was going to suggest at each council meeting, take out the regular, so it applies to discussion only and regular. The mayor shall encourage members of the public to limit their comments to 3 minutes, which we can change if we want, and to direct their comments to the council and not to members of the audience, city staff, or guests in the city.
I like that gets rid of the comments about the duplication.
So that was going to be my suggestion.
But I would say, I guess I would say that, we're beyond the recommendation at this point in time. And we've been beyond it with the 5-minute block up there. So I would take that out. I would just simply say that public comment shall be limited to 3 minutes. And set the standard that the public will be.
And, yeah, I like the fact that the previous policy says not duplication. And I like the fact this new one doesn't say anything about duplication. Just because everybody wants to say the same thing, that's fine.
So you would take out the part about the encourage members of the public. Because we're just-
Right, I think we're setting a standard now, so if we sort of retitle that and just say, at each council meeting, public comment period will be limited to 3 minutes per speaker. And the mayor will encourage people not to repeat whatever on an agenda.
Well, and the director comments to the council.
Right, and that language as well. Because we have a clock up there for a reason. I mean, we never used to have a clock. Then it made sense for the mayor to recommend people to limit it to 5 minutes. And we didn't have a lot of people who spoke, very long at the microphone when we were recommending. Now we have a clock up there, so if it's gonna go to 3 minutes, then we should just establish a policy that says this is how public comment will be conducted. Each person who wishes to address council at the beginning of the meeting, at the public comment period is limited to 3 minutes. If we go along with Chuck's suggestion, then, additional public comment will be held, at the conclusion of the regular business of the meeting, or something like that.
So where are we at? Do we wanna ask the city attorney to draft some language in the paragraph?
Yeah, but if we're gonna do more to change the rules, I think we need to talk more
Yeah,
about other changes that might be appropriate.
yeah, I think having council members sitting involved would be helpful.
Yeah, well, we would have to have this either on a discussion meeting or on a business meeting, right? Whatever language we would ask the city attorney to draft for this provision and any other provisions, because we've had a couple of things that we've talked about in the course of the past several hours, right? And you've got notes? I do. And we've got notes.
So this needs to be a voted agenda item that we're changing from 5 to 3.
This
So
is,
this is not just a discretion of the mayor.
no, this is a policy. This is actually a policy.
Needs a number.
Mayor Allen, did you want to bring up time too? Or something AJ said you had mentioned in the meeting that you wanted to talk about? Start of the meeting.
I don't know, Rob, do you want?
So we talked about, meetings starting at 7, or starting at 6 versus 7, so.
That's also.
Well, for people who are working, it doesn't really affect me. I could be there at 6 o'clock, but I don't know about everybody else. And I will say that, our original operating procedures set the meeting, those meetings all started at 7:30. And then at some point, we thought, we gotta move this to 7. And basically because we kept bumping up
Against the midnight.
late nights. And so we moved it to 7. If it's helpful to move it, I would suggest maybe 6:30 to see, another half hour and see how that works for everybody. Rather than going all the way to 6, another hour earlier, but, I'm
I just know
I'm
that
okay
we-
with whenever, so.
Are attempting more often to do a special meeting at 6 to
Yeah.
get.
If it's a special meeting an hour in advance, 5:30 is gonna be pretty hard.
Well, but we wouldn't need to, because then we could just do the special meeting as the first, we could do the closed session, for example, at the start of the regular meeting.
But then it's inconsistent with the public when the meetings start.
No, I think that's related to our notices. We don't actually have to have, like. Our policy resolution that says each meeting shall begin at such a, we don't really need that language in there. We can start our meetings whenever. We just have to give public notice appropriate under the Open Meetings Act as to when our meetings can be held. So if we just decide, I think generally that we're gonna start at 6:30 from now on. Unless, we have a special meeting or a meeting with our attorney that's scheduled earlier, then we just put out a notice saying the next meeting of the city council will start at 7 o'clock or 7:30.
Well, you do adopt a calendar
Yeah.
with times in there.
Right.
So you would have to amend that.
But we'd amend that, because we aren't required by law now.
Yeah.
So,
That's why I voted.
To the point about special meetings too, if we were to do that, special meetings require 2 sets of notices, 2 agendas, 2 sets of minutes, all of these things versus one meeting where you start a meeting and then go into closed session. That is one whole thing instead of like 2 agendas, 2 sets of minutes.
Right, and the
When you
reason,
have closed session minutes.
the
but-
reason we've avoided starting the meetings at these closed sessions is because the closed session takes an hour. And then if we started that at 7 o'clock, then we're going to 1 AM, not midnight, right? But if we move the whole meeting up by an hour and say start at 6, just to pick a time, then we could have that closed session at the beginning if we need to. And yes, the public will have to wait for the action to start, but that's gonna be on the agenda that we post, right? They will see that there's gonna be a closed session at the beginning.
But if we eliminate reference to when our meetings begin and by amending our operating procedures or the schedule of meetings, then you can do it however, whatever's the best way. You can just schedule a meeting to begin at 6 o'clock if we're gonna have a closed session. And schedule it for 7 o'clock if we're gonna be going in another direction.
So does this, go ahead.
Just real quick, I think the Open Meetings Act, I can double check, but I'm pretty sure that for your regular meeting schedule, it has to include the time of the meetings. It's listed for every
Do the
meeting.
notice, when we do the notice, right?
Oh,
No,
whatever you've got.
Beginning of each year, at the end of each year, you adopt the schedule for all meetings the next year. So you did that. So you have all your meeting dates and the times of every meeting. I think the time has to be in there as well, along with the location.
And I think.
In that
public access,
overall
7
publication.
o'clock is better for a public.
So so even if we change that,
You're gonna have to amend your meeting schedule and state
Okay,
the
got it.
time in that schedule of regular meetings.
I think the standard of to state too is 6 o'clock.
Is it really?
Yeah, Meridian, 6 o'clock. Well, some places do like Landon was telling us that Grand Rapids does like a day meeting for discussion and then they'll do business at night, so something like that, but. And then staff stays, another thing to think about too is staff stays after work, so they're there from 5 to 7 typically, and then the meeting starts at 7, and then they're there at night, so that's another thing. as well.
Saying the dates, times and places.
yeah, of its regular meetings, yeah, I see it.
City of Lansing starts at 7.
So thoughts about moving to 6:30?
I think 6 o'clock would be great.
Okay.
Personally, just because, but,
Yeah.
but,
Right.
I'm flexible.
In here too.
Yeah, I
That means
think-
if there was a special meeting, that would be 5 then?
No, we wouldn't need a special meeting because we would go into closed session starting at 6.
The public would have to be notified that we're not actually gonna cover anything until 7.
Well, or whenever the closed session is done.
And they're used to 7 o'clock anyway, so.
And it's gonna be on the agenda. They're gonna see that there's gonna be a closed session.
Right, so even by going to 6:30, we can do this in a way that doesn't really impact what the public's used to.
It's, the thought is trying to get away from calling a special meeting where we have to publish 2 notices, set 2 agendas, and then you have to cut off your recording, which takes 10 or 15 minutes, because each meeting is recorded separately
Because they're separate.
and then
meetings.
posted separately.
So
So it's more of a logistical issue than really.
I think it's important to communicate that to the community. They know clearly why we're doing that.
Yeah.
I think sometimes I forget about that, but. I got something quirky after we'll be done with this part, that one bring it up. I think we're done with this part.
Well, what do we want to do?
We get something how about we get something from Steve, we have it on a discussion only meeting, and I still think this is the time for us to take care of it if we're gonna take care of it.
Yeah, and we should.
Do it now while everything's changing, change everything so that rather than piecemeal, it'll change along the road.
And we should talk about it as all 5 of us. Yeah, and let's do a time change as part of the thing. We can reject it if we want to reject it, but let's at least talk about the time change.
Yeah, so within 10 days of the first meeting. So this just says, real quick, the Open Meetings Act require the public body post a public notice within 10 days after the first meeting of the public body in each calendar fiscal year. The notice must state the dates, times, and places of its regular meetings.
Which we've done.
For any changes in the, yeah, we do that. And for any changes in the schedule, of regular meetings, a public notice must be posted within 3 days after the meeting, which the change is made.
Right, so we can change, we just need to get the word out.
Okay,
Just
so it's-
repost after, if you pass this change.
Mhm.
Which is the earliest we can do that is on the 20th.
You have a new schedule created. And with a new time, basically the same dates, new times.
Yeah, which we got posted on the website and social media and on the doors and all that kind of stuff. Too, so.
Okay,
So
so we
I'll be
got,
on for that
This is
one.
a February action.
I'm thinking February,
Yeah.
It's not, it's new to see we're already out. Any further discussion on these public comment issues or the operating constraints?
I think as long as we have the whys correct.
Yeah, the wise need to be in there.
The whys, if it's just simply convenient for staff that may not communicate very well for the public, but I think if you say in general, it's an available time, I don't know, just want to make sure that we have the list of the whys, even though I feel like the staff is probably the most primary thing, because they've already worked all day, and they're working into the evening. Are we giving the public just as much access to us?
Well, here's the other question on that. Like, you only invite staff to the meetings who are gonna make a presentation, right?
Right, if they have an agenda.
But typically, a lot
Other staff come just
of
because they're
directors come.
hanging out with you.
Okay, but they're not required to be there, right?
They're not required. Some watch it from home.
Okay.
Can I offer?
But I do want to balance something,
Yeah.
going back to your
Yeah.
point. Your meetings are for the public. We're there to provide you information so you can make an informed decision. I don't want it to appear that staff is driving the change. We're just talking about logistically, when you call a lot of special meetings, there's a lot of extra work with that.
I understand.
That's it.
In a lot of things that can also go wrong too, right? If for some reason the meeting ID on the Zoom meeting is not working like was happening the other night, then what happens when the Zoom doesn't connect and we just got out of the other Zoom meeting? Things like that, the logistical errors too, but
Do
yes.
you want to
I would-
offer your perspective?
No, I was gonna say what Robert said.
Appreciate that.
Just real quickly, quirky thing happened last night at Hannah Center.
Yeah.
We
I
were.
heard you wanted to leave early.
I won't confirm or deny that. The alarm went off last night and, within that meeting, they didn't kind of know what to do. And it made me think about a council meeting. If, something like that happened during our council meeting, the alarm goes off, everyone has to exit the room. The alarm doesn't go off until the fire personnel.
Doesn't get reset, yeah.
So I just wanted to bring it up because maybe in your time of surveying that you've dealt with it maybe once or twice, but I never had the experience, so.
We actually, in the past, I think it's only one occasion, but we had a new council. So at the beginning of whatever term that was, and I can't remember whether that was when Eric and I were both on, or it was before. We actually had a presentation from police and fire as to what we were supposed to do when an alarm went off, when we had an active shooter in the room, when we had danger that occurred. And we haven't had that in many years. And I think it would be useful for us to be in there for a little bit of training from fire and police as to what we should do in certain circumstances.
Yeah.
It is not, it's unfortunately not out of our thought that we could have an active shooter in that room.
Yeah.
And we need to be prepared as to what we should do. In the city hall, in the courtroom, there's a small room, sort of a
Jury.
a jury room right off the courtroom, and we were to essentially run into that room. And we don't have anything like that at Hannah, so we don't have a real plan, I don't think, in place as to what should happen should the room become a dangerous place. So,
Or even for something like a fire alarm going off, what do we do?
Right.
Do I call a recess to, before we, and then?
Yeah.
I mean,
And tell everybody that's it.
So it would be useful for us to have a little bit of a presentation on that, and also some thought as to what the game plan is in case that happens. So I don't know if that answers your question.
No, it does. I think you need to have something in place because.
I think we should practice. it.
So did you end the meeting?
Yeah, we had to leave the room. So they adjourned, we adjourned, they adjourned, the commission adjourned, and then we went out, talked a little bit, and then everyone left. But it was pretty chaotic because at first it was like, well, we'll just try to do the meeting, and then it's, no, we gotta get out of here because legally, it's alarm, and so it was just a little
So you
confusion.
officially adjourn the meeting.
The last thing we
Ended the
want,
meeting.
yeah, the last thing we want during a council meeting is not have a plan of what we do.
Steve, have you encountered this? You
No,
no?
I haven't. No,
Okay.
I'm going off and
Yeah.
I'm certainly not an active shooter or anything, but,
That's why I'm saying. it.
yeah. You know, obviously, it was good to adjourn the meeting, at least get that in the record of the minutes and whatnot. You know, the only thought I have is if you think it's just a temporary thing, as the mayor can declare a recess. That way, if you just have to leave shortly,
Yeah.
you can come back in and resume the meeting, and a recess is telling everybody, we're just taking a break. Can you even say that? We might be able to come back in here. But so much is going through your head, adjournment is just fine under the circumstances, but that's the only other thought I have.
Okay.
Mhm.
So we'll play a little bit by ear, but I
Yeah.
don't want to play too much by ear.
Yeah, I mean, in a real emergency, you're not that time to do it, so, yeah, you're gonna be thinking of other more important ones.
And when you walk outside, you don't talk to each other.
Yeah,
Well, right.
right,
It's
yeah,
all
very-
real quick.
well, not about business, but yeah, about what's happening, sure. Resuming your normal civic and.
I know I'm asking.
Okay, so I think we have concluded our agenda. Well, I guess we can't do matters arising because they're not on the agenda.
Right.
So, anything more on, room layout, public comment or orientation? If not, is there a motion to adjourn?
So move.
First time to say so moved.
Moved
Second.
moved by Meadows, second by Will, and all in favor, say aye.
Aye.
Any opposed? Okay, thank you all. I think this is a really productive session.